Hello and welcome, and thank you all for joining us today as we discuss the impact of the Uniform Partition of Heirs Property Act and the work that remains ahead. Heirs property occurs when multiple descendants own a home or land without a clear legal title, leaving those families vulnerable to forced property sales that can strip communities of generational wealth, often at below market prices and against the wishes of the families involved. The UPHPA was designed to address exactly this problem, offering legal protections that give families a fair chance to keep their inherited property. It has now passed in 26 states, with legislation introduced in 5 more, but adoption alone does not guarantee impact, and implementation varies significantly across jurisdictions. So it is a tremendous honor to announce that today's program will open with a keynote from Dr. Thomas Mitchell of Boston College Law School. He is the foremost expert on heirs property reform, and he will be followed by 2 panels and a research fireside chat. The first panel focuses specifically on the state of Georgia, examining how the UPHPA has taken shape there, with perspectives from legal practitioners, from advocates, and from community organizations working directly with the affected families. The chat will then zoom out further to the research landscape, and then our second panel broadens the lens further, drawing on experiences from other states, New York, Vermont, and Pittsburgh as well, to explore what implementation looks like in different geographic contexts. Research plays an important role in documenting both the scale of heirs property loss and the real-world effects of legal reform like UPHPA. And we hope today's conversation advances that understanding. But before we do that, I'd like to go over some housekeeping notes. First, today's event is hybrid. Welcome to those of you watching online. We're thrilled to have you here. The event is being recorded, and the recording will be posted online on our website in the coming days. Biographies for all of today's speakers and slides are also available on the event webpage as well. And there are live captions for virtual attendees. You're welcome to turn them off if you would prefer not to have them on during the call. Virtual attendees are invited to submit questions, as well as those of you in the room. Online, you can use the form shared in the chat. Those of you in the room can scan the QR code on your table to submit questions via the form as well. And one last, but certainly not least thing, I would like to thank JPMorgan Chase, who has been a thought leader on this topic and who is supporting today's event and the related urban brief on this topic later this month. These efforts are part of a broader collaboration between Urban and the JPMorgan Chase Institute over the past 10 years. That collaboration has supported urban scholars in leveraging research, data, and analysis to inform policy and practice, and we're deeply grateful for their partnership. Housing has been a core focus of our work together. And on the topic of heirs property in particular, it's been fantastic to collaborate with the folks at JPMorgan Chase. They are a leading voice on challenges and solutions in the field and committing philanthropic capital, business engagement, and thought leadership in the policy space. I'm delighted we're joined tonight by a leader at JPMC who can speak more about the many ways they are moving the needle. It's my pleasure now to introduce Olivia Barrow-Strauss, Vice President of Neighborhood Development at JPMorgan Chase. She's worked across a range of corporate responsibility teams, leading philanthropic and policy strategies to advance the firm's housing market affordability priorities and drive meaningful impact for people and communities. I'm so glad she's here to lend her perspective and as a moderator for our second panel and help us frame up the day with opening remarks. Please join me in welcoming Olivia to the stage.
Thank you so much, Yannicka. Good afternoon, everyone. My name is Olivia Barrow-Strauss, and like Yannicka said, I lead housing policy for the JPMorgan Chase Policy Center. Thank you to all of you for joining us both here in person and online for this important conversation on heirs property and the Uniform Partition of Heirs Property Act. And first, just a huge gratitude to the Urban Institute for hosting us here today. Like Yannicka said, JPMorgan Chase has collaborated with Urban for over a decade, and it's always such a joy to be in person with the Urban team and really see how you all bring together that rigorous research and policy analysis and data to difficult conversations that have real impacts for communities and individuals, and then complement that work, right, with conversations like this where we convene stakeholders for practical practical solutions. And I think that is especially true around housing stability and wealth building, which has long been a priority for JP Morgan Chase because we know that housing sits at the center of so many outcomes, right? It's financial stability, it's community health, it's intergenerational opportunity, and so much more. But heirs property, which is inherently unstable form of homeownership, can quietly undermine all of these aspirations. We know that without clear ownership, multiple family members may share ownership rights without an agreed upon path for decision making. And that type of uncertainty can limit a family's ability to maintain the property, to invest in improvements, to access financing, or even respond quickly when a crisis occurs. And that leaves homes vulnerable to disputes and forced sales. And just to make that very clear, people are then at risk of losing not just their home, but also the wealth that they've built. And so at JP Morgan Chase, we are mobilizing our resources to help communities resolve and prevent heirs property challenges. We have deployed more than $16 million in philanthropic capital since 2023 to support community-based organizations, legal service providers, researchers, and more to advance strategies on the ground. And we have also mobilized our own research and policy capabilities to help build industry awareness and advance solutions that work. And one of those policy solutions is the Uniform Partition of Heirs Property Act, which JP Morgan Chase has helped support in a number of states. So I'm very excited that today's event will offer a comprehensive view of UPHPA. We'll talk about success stories, we'll talk about barriers to enactment and implementation, and we'll look at insights so that other places can adapt what works to their own state and local realities. The first panel will focus on a deep dive in Georgia, and we'll bring local on-the-ground learning about the impact of UPHPA across the state. And then our second panel will zoom out. We'll look at how UPHPA is playing out in other jurisdictions and housing markets with perspectives from New York, Alabama, Vermont, and Pittsburgh on what these challenges really look like in different contexts and what lessons might translate across state lines. And then to follow today's event, we are very much looking forward to a forthcoming UPHPA brief from the Urban Institute with support from JP Morgan Chase that helps shed additional light on policy implementation and lessons learned. But before we dive into the panels this afternoon, we are honored to hear an overview of the UPHPA from Professor Thomas Mitchell, who is the Act's principal drafter. Professor Mitchell is a professor at Boston College Law School and the founding director of the Initiative on Land, Housing, and Property Rights. He is a national expert on property issues facing disadvantaged communities and has contributed extensively to research and policy development in this area. In recognition of the impact of his work, he was named a MacArthur Fellow in 2020, otherwise known as a MacArthur Genius. And in 2021, he was awarded the Howard University Award for Distinguished Postgraduate Achievement. Professor Mitchell is a graduate of Amherst College, the Howard University School of Law, and the University of Wisconsin Law School, where he also served as a William H. Hastie Fellow. He is also a friend, so it is an honor to welcome Professor Mitchell to the stage.
Good afternoon. Okay, so I'm going to take you guys on a forced march because I don't know the depth of experience or the breadth of experience of many of the in-person attendees and our Zoom attendees. And so I'm going to try to do this in about 20 minutes and have like 10 minutes for Q&A. All right, so when I started research in the mid-90s, heirs property kind of fit into, or one of the drivers of Black farmland loss, and that's kind of how it was understood at the time. There's been just a substantial decrease in the number of acres Black farmers have owned in this country, with a high water mark being around 1910 at about 16 million acres, and we're now down to just a few million acres. On the, outside of just the agricultural sector, we also have, gaps, as we know, in homeownership, black-white gaps. Somewhat depressing even after the Federal Fair Housing Act. We have the black-white homeownership gap today is worse than it was in 1960 when we were in the throes of Jim Crow, for a variety of reasons. So one of the things I want to emphasize is that when I started my research, and this was when I was doing the Hasty Fellowship, my master's at University of Wisconsin, there was, outside of heirs property owners and legal aid or community-based organizations who worked on heirs property, there was little understanding. It wasn't a recognized topic in law school. It wasn't in any case book, wasn't in any treatise. And there wasn't any case law. I mean, I found one case from Arkansas, that was it, that was a published opinion. And how I stumbled it was the field research I did in, mostly rural parts in several southern states, in Appalachia and eastern Kentucky. And so this kind of are some pictures from back in the day when I started this work, 30 years ago when I was 10 years old. But that's how I found out about it. The picture in the top right is actually a meeting of black farmers in North Carolina. And this was when the Pigford versus Glickman, which was the big class action lawsuit black farmers brought against the USDA. There was a proposed settlement, and these black farmers were meeting to discuss it. And somebody at the meeting early on said, oh, we have this attorney from Madison. And I had, the first coffee break, 3 or 4 families descended upon me. And they were just really kind of anxiety-ridden, and they wanted to tell me about their heirs' property. I had absolutely no idea what they were talking about. I thought, are you talking about heir rights? And as they talked to us, I was like, oh, this is tenancy and common property. But then when they were talking to me about how the legal system worked, it wasn't validated by anything I had learned in law school. I told them I'd go back to Madison, do some research. I looked at every first-year case book. I looked at every treatise. Nothing they said was validated. But I remembered that a couple of them told me they had legal cases. Some were resolved, some were ongoing. And I said, so I wrote back to them and said, could you send me the documents for judicial opinions? And when those opinions, they sent me a $1 million envelope, showed up about 3 weeks later. I was still deeply skeptical. And as I started reading through, literally everything they told me was validated. So then I realized there's basically this alternative system that if you're disadvantaged, partition law works differently. And as I've often said, it was flying under the radar because there was no case law that, like the databases we rely on, Westlaw, Lexis, no cases. But it was hiding in plain sight. Like all you had to do was go on the ground. All right. Just a couple of things as the field has developed. So there was a narrative when I started working on this that conflated black agricultural land loss and heirs property. There was a narrative that black farmers were on the verge of extinction and thereby heirs property owners were on the verge of extinction. Like Juan Williams wrote a book and basically said that, although. And so we've gone from that understanding 30 years ago to this just really exciting empirical research in the last few years. These various studies, you can see Ryan Thompson is here, and at the national level, and we're now having studies at the local level. So what we now know is heirs property is not some trivial matter. And we also know that this property falls out of being heirs property, but there's new heirs property created all the time, and it's pretty stable. So just a couple of high-level things. When I started, the only discussion really about heirs property legally was about partition. There had been some earlier work that more focused on the problem of the lack of clear title. But certainly in my world, that wasn't even talked about. So let me just kind of give you a thumbnail sketch. So heirs property is incredibly problematic ownership. Partition falls into the problem of the lack of it being secure, being unstable. It's not the only reason heirs property is unstable. There's other reasons, but that's one bucket. Another bucket is that the ownership, and this is once again from some of my field research or just being out in the field and families started telling me about this other problem, is that it's what I refer to as gridlocked ownership. If you own heirs property, and this is if you own tenancy in common property under what we call the default rules, you can have changes in how you use or manage the property, but there's a catch, and the catch is you have to get 100% agreement among all of the owners. This is called the unanimity requirement. So for a lot of families, they're frozen in time. They can't use the property in a way that's going to vindicate whatever their goals are. And then there's obviously this problem of most heirs property owners lack clear title. So if you don't have clear title of the property, you can't use your property as collateral to get a commercial loan. And there's a whole panoply of governmental programs from the local, county, state, and federal level, many of them designed to help heirs property owners in terms of their condition of their properties, but then they're ineligible for them because you need clear title. And then there's other kind of laws that kind of make homeownership more affordable, like having the homestead exemption. But if you have heirs property, it's almost impossible. Texas is the first state to try to address that, but in most other states, it's not. So I'm going to focus on that first basket, the insecurity, right, the instability, and link it to partition law. And the folks who are most vulnerable to having a partition lawsuit filed against them that could result in losing their property and their wealth tend to be, property owners we say who are property rich and cash poor. So they're low income, their property is the biggest asset they have. They lack access to affordable legal services. And kind of connected to that, but not only because of that, there are low rates of will making or estate planning. But most important is, or not like one of the other important things is their property is property that's in areas where there are rapidly appreciating real estate prices. And this could be in urban areas or it could be in agricultural areas. Just let me summarize that last thing. There's, in terms of, we know about a lot of racial gaps in this country in healthcare and incarceration. I can just keep going. One of the least known is the racial estate planning gap. And so this, let me just kind of boil it down. This is not surprisingly in any racial or ethnic group, rates of will making or estate planning go up the more educated the people are in that demographic. And so that's true with African Americans. This was a study from about 10 years ago. And it shows that the highest educated Black Americans, those who have at least a college education, they do have the highest rates of will making among Black folks, but it's only 32%. In this study, the lowest rate of will making among white American adults was white Americans with no high school degree, and their rate of will making was 57%. So just kind of think about that for a sec. All right, so let's get to the UPHPA. So I don't have time to do the Property 101 and give you a whole, synopsis about partition law, but let me try to do this quickly. So partition law is the property law that if you own a tenancy in common or a joint tenancy, that if you have one of the common owners who has an undivided fractional interest wants to exit the ownership and can't work that out consensually with the other owners, you can file a partition. There's actually a number of remedies that a court can order in partition, but the dominant ones are either a physical division of the property, if the property is large enough, like a farm or a rural property, or a forced sale of the property. Most of the state statutes ostensibly said that the physical division, if possible, would be the preferred remedy because that's seen as being more consistent with maintaining important property rights. In fact, state courts judges throughout this country for decades had de facto reversed the presumption and made the forced sale the preferred remedy. These forced sales are not under market value conditions. They result in properties that are sold for 30, 40, 50, 60% less, sometimes 100% less than their market value. And this is the context of where the UPHPA comes in, because we were seeing that partition law was a significant driver of Black property loss. So let me just kind of give you the UPHPA has a lot of bells and whistles, but let me just focus on three of its most important provisions. The first is the buyout. So under the UPHPA, if you have one of your fellow common owners files a partition action and they request the court to order the forced sale of the property, the other common owners who want to maintain ownership of it are entitled to buy out the fractional interest of the person seeking the forced sale, right? So that's number one, all right? I should say, oh, no, let me just go to number two. The second pillar is we do agree with the state statutes that say that where possible, the preferred remedy should be the physical division. But what the courts had come up with that undermined that whole preference was they had reduced it to what I call the economics only test. They would make an analysis, they said, that did the property have economies of scale? And if it did, they would order the for sale. And they basically said all the other things these families say is important to them, that it has heritage value, cultural value, historic value. Well, we can't quantify it, so we assign that as zero value. And so what I'll tell you is this economies of scale, like, benefit is mythical. But that's what, so under the second pillar, we say, you know, we agree that there are important economic considerations for a court to consider. But also there's non-economic. There is the historic value, the heritage value, the cultural value, and the impact that a for sale would have on somebody who's lawfully using the property, including for basic shelter. The court should take that into account. So we basically buttress, fortify, actually give standards that a court has to apply. The third thing is we acknowledge that in a variety of partition cases, if you're dealing with a single family home in Southwest DC, you can't chop it up. That the sale might be the most just, but we say if you're trying to vindicate the goal of wealth maximization, instead of having these auction sales at a courthouse that have none of the attributes of a sale under market value conditions, right? Court orders the sale can happen in 2 weeks at the courthouse. The winning, no right to inspect the property, and the winning bid has to be paid in cash that day. Not surprising that it's not returning a great price. So we replaced it with something that we call the open market sale. It's actually an idea I got from when I was in Scotland, and I met one of the leading property scholars there because they had some reform in the Scottish law of partition in like the early 70s, and they told me about that. So under the open market sale, court appoints a real estate broker. Broker's got to list the property for the fair market value appraisal. Anybody who was interested in the property can inspect the property, and they can make an offer contingent on getting financing. Does that sound like a sale that's more likely to return a better price? Yes. Okay. So I want to say there's between the first remedy and the third remedy, it's a little more complicated than some people look at it, because when we built it with the goal of having what we call shark repellent. So from a real estate speculators, they're not buying out somebody's 2% interest to only get bought out themselves. They're not acquiring somebody's 2% interest to then have to pay market value at an open market sale. And so it's designed to suppress, it has a prophylactic effect in terms of suppressing abusive filings of partition actions. All right, so here's where we are now, and I forgot to tell them to do a PowerPoint, but I mean a link to the UPHPA. But if you had clicked on that hyperlink, here's what you would have seen. You would have seen 24 states, the District of Columbia, and the U.S. Virgin Islands that have enacted into law. So far, in the aggregate, those states and the District of Columbia, U.S. Virgin Islands, constitute 70% of the U.S. population, because 7 of the 10 largest states have enacted it into law. So it's literally, sometimes I say, from California, Florida, Connecticut to New Mexico, throw in a bunch of Midwestern states, Hawaii, and the U.S. Virgin Island. And what that shows you is we've successfully been able to expand the understanding of heirs property from something that only impacted Black families who owned farmland in the rural South. And it's probably true that the majority of heirs property owners are white, disproportionately Black and brown, but impacting families throughout the country. So these are just some representative photos of some of the states. You know, the one in the top left you might recognize, that's Governor Nikki Haley. I was a little sad. The one is a blurry photo in the right. This is when, so I was there because she invited me to a ceremonial signing because it was named after the Black state senator and pastor of Mother Emanuel Church in Charleston who was murdered. And so in South Carolina, it's called the Clemente C. Pinckney Uniform Partition of Heirs Property Act. In the bottom right, that was the governor of Virginia, and that's the tall guy is Ralph Sampson, and any basketball fans. And I got invited to the ceremonial signing, but my wife has type 1 diabetes, and it was during COVID, and she would not let me fly. So, you know, you would have seen that a more balanced. Some of my friends and family members think something different about why I was. Anyway, I'll leave that alone. All right. So just a couple things in terms of we have, you know, far exceeded the expectations. The Uniform Law Commission thought the UPHPA was going to be a total failure. They thought 0 states were going to enact it. And today, the median Uniform Act that the Uniform Law Commission promulgates gets enacted in 9 states. 25 years ago, it was like 20 states. Their least, because the hyper-partisan times we live in, the least successful portfolio of all their uniform acts is their property acts. The median number of states for all their property acts is 2. Ours was the first one that they interacted, that they promulgated, that had kind of a social racial justice, and that's why they thought it'd be a total failure. So we are far beyond. We are like the extreme outlier. It's now become one of the most successful uniform acts in the last 30 years. And some of the successes, you know, kind of like there was a long-term vision. I actually think the act is pretty good. But in every state, we build coalitions. And the coalitions are grassroots and grass tops. And prior to the UPHPA, any major attempt to reform partition law, which was all in southern states, pretty much failed. But it failed because it was wonderful people, very committed people, tended to be civil rights folks, but they had no allies in terms of major power brokers. And we have the National Association of Realtors, the American Land Title Association, but we got the grassroots groups too. And that's what we try to do in every state, is do that. The other thing I've learned, an important lesson, is messaging. When we are in the South, the Deep South, when we advocate for it, we lead with this is about property rights and protecting family real estate wealth. When we're in the Midwest, it's about saving the family farm. When we're in California and DC, we do lead with a racial justice. And so we're flexible. And I think I cannot tell you how important it is to message appropriately. All right. So, you know, this slide has like too many things on it, right? I mean, so it has helped thousands of folks maintain their property and their real estate wealth. It has, one of the things is it's really helped build the heirs property field. The amount of media attention, the UPHPA, and it's funny because UPHPA sounds wonky, but it actually, like when I travel, it's got what my daughter would call, it's got riz. Does anybody know what I'm talking about? Yeah, it's got charisma. People talk about the UPHPA with passion. It's amazing to me that you're dealing with a arcane property law and very technical, you know, drafting. And, you know, so I think that is important. So going forward, though, you know, sometimes I hear from people, and they're like, well, you know, the UPHPA didn't solve the folks lacking clear title. And I'm like, no kidding. Because it wasn't designed to do that. It was designed to solve one problem with a recognition that there's several other problems, and hopefully that it's been a catalyst to have focused people's attention on addressing others. And we're going to hear from a couple people, Scott Kowanowski, I'm not calling you out, where they have, you know, taken it to another level in terms of dealing with other problems. But dealing with these problems is going to take collaboration. It's going to take different sectors working. And so I just wanted to give a couple ideas, like this gridlocked ownership. So I'm part, and Scott and some others are part of, we're drafting another model state statute to deal with some of the gridlocked problems. We're going to test run it in New York, and then we're going to try to take it national. Another problem, and I think Olivia referred to this, is that most heirs property owners don't have a private agreement among themselves about how to operate the property. There are wealthy tenancy in common property owners, including ones who own investment property, and they always have something called a tenancy in common agreement, a TIC agreement. So our initiative is spearheading the drafting of a modified TIC agreement that's more relevant for heirs property owners. We have two major law firms that are serving as pro bono counsel for us, and then we're also going to ground truth it with heirs property practitioners, attorneys, both some people in the room, but also then some people at legal clinics. And then just in terms of the lack of clear title, there's stuff that falls into the basket of being preventative, like trying to have people have an estate plan, like doing wills clinics. There's stuff that's curative, which is harder, trying to have lawyers work with folks who don't have clear title, to clear up their title. That's very hard work. But then sometimes you can adapt. So there's something in the 2018 Farm Bill that allows heirs property owners who are farmers and ranchers to actually qualify for some USDA programs, even though they don't have clear title, but if they can show alternative forms, proof of ownership. This is just an example of one of the things my initiative is doing under a grant we have from Harvard. It's called the Homeownership Estate Planning Project. We are partnering with a leading nonprofit housing organization in Boston. They do a bunch of training for prospective first-time homeowners and some homeowners after purchase in terms of financial literacy, whatever. We've added a module on the importance of estate planning to their homeownership education. We've already had 2,000 people take that course, and then as a pilot, we're taking 30, 40, 50 of those families, and we're steering them to our other partner. Our other partner is the only legal clinic at Harvard Law School that does estate planning. So for those families, they will have a will or a simple trust drafted. All right. Quickly wanted to show DC as a great model. So I mentioned there have been, I'd say I put it in the superstar states of states that enacted the UPHPA, but then went beyond. New York, you're going to hear later from Scott about what they did in terms of, UPHPA 2.0 and beyond. Virginia is also in that, and then DC. So in DC, they enact the UPHPA in 2023. But the UPHPA raised the awareness of Mayor Bowser and others, and so they then have funded a couple legal aid organizations. One that just does legal aid for folks who are very poor. Others at that next level up offers kind of a reduced fee, and then the estate planning attorneys in DC. They actually at the probate court. They have this little center, a little booth that provides education and an opportunity for heirs property owners to meet an attorney and get a referral. So DC's been great. All right, this is just the last slide. If anybody's interested in what the initiative on land, housing, and property rights, we have a research program that Michael Neal serves as our research director, splitting time with his time here at Urban. We have a policy team, we have a community engagement team. And then just, so that's just, if anybody's got an interest in that. And then lastly, some people have an interest. I was lead co-editor for an ABA book on heirs property in the Uniform Partition of Heirs Property Act a couple years ago. And I just published a short, 7,000, short for us, as law professors, article, kind of giving a history of the development of the heirs property field in the last 55 years. That seems to have been just posted it about a month ago, and it seems to have been quite popular. So if anybody wants that. Okay. So I'm happy to take some questions. Oh, I guess I got to take out my glasses. Okay, so this is for kind of the legal geeks in the room about should we, as property law has developed, there used to be a preference that if a legal document was ambiguous, the property would be deemed to be a joint tenancy with what we call a right of survivorship versus a tenancy in common. And then, there was this notion that was stripping people of property rights, so then the tenancy in common became the presumption. And the question is, how helpful would it be? It might be helpful. I don't see it happening at all, like anytime soon, right? The property bar, the real estate bar, they're inherently conservative. I meant that with a small c. They don't like changes. And I don't see something like this prevailing anytime soon. Okay, so where do you think social science research can make the biggest impact in supporting the UPHPA and its goals? So I think on this question, I've been advocating for years that I really wanted there to be social science research, also legal research on the impact of the UPHPA. So there's a variety of ways. We talked about, Olivia mentioned that anytime you have any change in the law, including legislation, there's a lot of people think it ends there. It doesn't end there. There's implementation. And that's true with the Affordable Care Act. That's true with setting speed limits, right? And so it's, obviously we shouldn't assume that just because it passed, it's miraculously working perfectly. And so just kind of finding out, and then there's differences in jurisdictions, right? In terms of how knowledgeable is the judiciary in any state about it, because under the UPHPA, they're required to apply it. But if they don't know about it, and so it turns out we have states where there's been great judicial education, and the state court judges are very knowledgeable. There's other states we found out where that's not the case, right? So that suggests well, maybe there should be judicial education. So I think that's one thing. I mean, there's so many things that, about the UPHPA. I just know anecdotally, I've heard a lot of people talk to me about the increased sales prices. That's what you would expect given the changed process. But it would be good to document that outside of the anecdotal stories I hear regularly, right? There should be research looking at the expense, in terms of how expensive it is for these families to actually litigate a case. Not just on they would still be similar to any partition case, but just in terms of, the real world, cost. There should be research on how many heirs property owners actually know about the UPHPA. Now, we drafted it in a way that theoretically they wouldn't have to know about it, because the courts are supposed to know about it, and if there's heirs property, they're supposed to apply it. But it would be helpful if more heirs property owners actually kind of knew about the act. All right, so anyway, the point is that I'm really excited that of the research that Michael and his team has done here at Urban, as kind of it's really only the second assessment study I'm familiar with besides Cassandra's study. So there's tons of things that could be done. You mentioned New York has gone above and beyond. What are some first steps states can take to do the same? I mean, so one of the things is just in terms of creating an ecosystem where there's sharing of knowledge, right, from one state to the other state. So I mentioned that Virginia went and has done an additional statute addressing a different problem, the problem with tax sales. We have, New York's very active. So part of it is just not having folks work in a silo, is having kind of a sharing of information about what could be next steps. And I'm sure Scott will talk a little bit more about that. Somebody has a very specific question about the UPHPA in Minnesota. And so I mentioned, just to level set, sometimes I hear people say we're at 26. Oh, we could get to 50. No, we're not going to get to 50. At 26, I already told you that we're triple the level of success of the standard Uniform Act. And then if you take the Uniform Property Acts, we're now at 13 times the success rate. I think when all is said and done, and I feel like sometimes I shouldn't say this, but I think we could have a path to getting somewhere in the low 30s if all the stars lined up. But there's just going to be certain states we're just going to meet resistance. Minnesota right now is in that. I'm not saying Minnesota will never be possible, but it's the real estate bar there, and I've met with them a few times, and they're hardcore. and somehow they think that the threat of a forced sale yielding a fire sale price is great. And until they stop thinking like that, they have the ability to stop it in Minnesota. So that's Minnesota. Like I said, you know, I'm not giving up on Minnesota. I'm very proud of Minnesota in many ways these days for other reasons, which I won't get into. Journals, where should I begin my search for data? Okay, once you get done. Yeah, so one of the questions is, in addition to trying to reform certain property laws dealing with tenancy and common ownership, essentially, would it be productive to then also seek to reform some laws of trusts and estates? Totally. And so I'm just going to take one more question. On that totally question, there's a law professor at Howard University School of Law who's actually working on some estate planning reforms. Her name is Kiva Terry, if anybody's interested. And I'll just take one last one. Yeah, all these questions are great. I'll just take the one, I don't know, I'll take the personal one. They said, like, why did I get interested in heirs property originally? Okay, so I had, went to Howard Law School. I spent 2 years working at a large law firm here in DC, Covington and Burling. I clerked for a federal judge. But, I always knew my time in big law was going to be abbreviated. It was punching the ticket to get on to the next thing. And, when I was at Howard, I had a couple of my professors were just on me about, you should be a law professor. And, I get it. I did well. And they trying to, like a lot of mentors, their biggest idea is you should do what they did. Anyway, so long story short, I ended up at Wisconsin doing this research. And the master's program, this Hasty Fellowship, was pure research. And when I thought about what I was interested in, there really wasn't anything I took in law school that I was like, oh, I want to take that to the next level. Or, I did mostly insurance coverage work at Covington. And I was like, God bless the people who love that. It's not me. And I thought, I was doing the research proposal. I was like, what really animates me? Like, what do I think about? And I realized I grew up in San Francisco, and I was born in '65, so I wasn't 10 when I started doing my heirs property research. And San Francisco is the major city in our country that had the biggest reduction of a black population of any city in the United States in the last 50 years. So when I grew up, 13.5% of the population in San Francisco was black. Today it's like 3%. That 3% is like largely homeless and socioeconomically disadvantaged. So I was seeing these changes in, people being pushed out, businesses being pushed out. So I just thought, like, this whole notion of displacement is something I thought about a lot. Even I didn't take any urban and policy classes or anything, but I always was thinking about it. And then, even though I grew up in San Francisco and I was a junior at Amherst, my grandfather in Newark died, but, I went to the funeral. And his family, he was born in Americus, Georgia, in Southwest Georgia. And I saw my family in Newark is like incredibly poor. But when I stayed with them, I saw these photos going back to Americus. And I don't know, somehow I was like, I want to learn more about my family's heritage in the rural South, the African-American. And I was like, this is when I was in DC, I was like searching for a topic. And I couldn't find any topic when I did the traditional kind of legal research you would do. But I was at the Library of Congress one day, and I came across a newspaper article basically talking about an heirs property family and describing like a partition sale. And I was like, I don't know if this is true, but this seems like, and this is going to be a legal term, this seems like whack. And that became the genesis of my heirs property journey. Okay, so I think I only went 3 minutes over, sorry. So I'm going to introduce the next panel by, I'm sorry. And by introducing the next panel, I'm just going to introduce the moderator, my good friend Sarah Stein from the Federal Reserve Bank of Atlanta. I'm not going to tell you, she's got a very lengthy title. She's very important.
Everybody settled in. That's good. All right. Good afternoon, everyone. We're so glad to be here today. My name is Sarah Stein. I'm at the Federal Reserve Bank of Atlanta. I'm a senior advisor there. I can't really speak to my own importance, but I do think the work that I do is very important, and I'm so pleased to be here with all of you to get to talk about it with a panel of absolute experts who are grounded in Georgia and Georgia's experience with heirs property and the UPHPA. So I should add that my thoughts and comments and those of the panel are not necessarily reflective of the opinions of the Federal Reserve Bank of Atlanta or the Federal Reserve System. And, you know, Thomas gave us a wonderful sense of the history and development of the Uniform Partition of Heirs Property Act, and really how it is like a great example of what we talk a lot at the bank about, authentic demand, that you bring work forth and you think that it comes from a place of great need, and when you write a uniform act and it gets adopted by 25 states or 25 jurisdictions, I believe we're at. Thomas, you can correct me. 27. We're at 27. 40. What?
26.
26. That's right. I think I forgot about. Anyway, yes. My apologies. Anyway, even more even more impressive. It is a testament to the authentic demand for this legislation and, as Thomas put, the problems that it aims to solve, which are not all of the problems that surround this area of law we refer to as heirs property. And so we're going to dive a little more into the Georgia context on this panel. And in Georgia, as perhaps we are all familiar, the UPHPA was enacted in 2013. So that gives us 13 years of experience. It was the second state in the country to enact the UPHPA. And just to give a little understanding of how this will go, we're going to have a panel discussion for about 45 minutes and then 15 minutes of questions and answers from all of you. So thank you. And let's take a moment and meet our panelists. I asked everybody if they would share their names, what their role is, where they are, and really to give us a sense of the first time that they learned about and interacted with the Uniform Partition of Heirs Property Act. And I'll say mine. I'll get the privilege of going first just to give an example, right? And that is that I actually, I encountered it during law school because I was probably a very unusual and fortunate to have had Sharon Hill of Georgia Appleseed come to, I was at Emory at the time, and talk about heirs property while I was early in law school. I was quite interested in the topic, curious about it. I, for some reason, had fallen in love with property law and really just sort of followed the topic. And so then by the time there was this effort to pass it and then the eventual passing of the act, I was familiar with it. But it wasn't until a few years later that I really got to engage with cases and start to understand the complexity of what was at stake. So Sarah, if you could go
Sure.
and introduce yourself, tell us a little bit.
Sure. I'm Sarah Mancini. I'm the Managing Director of Advocacy with the National Consumer Law Center. At NCLC, our mission is fighting for economic justice for low-income consumers, low-income people, and we focus on a range of issues involving personal debt and finance issues. My background is primarily focused on homeownership and foreclosure prevention. I started off at Atlanta Legal Aid in 2007, hit the ground, and of course the subprime foreclosure crisis started immediately. And so I learned about homeownership issues and protecting homeownership from defending homeowners against abusive predatory mortgage loans that were driving them into foreclosure. And my first experience with the UPHPA was in talking with a client who was facing a partition action filed by an investor in Atlanta. This person lived in a gentrifying area, and knowing that because Georgia had passed the UPHPA, there were options for this person.
Hi, everyone. My name is Whitney Knox-Lee. I'm the founder and managing attorney of Wills for the People. Our motto is, we believe estate planning is for everyone. So I'm primarily an estate planning and probate attorney, and over the past couple of years have been getting into heirs property work. And so I actually am new to the UPHPA. I am very awkward saying those letters because I feel like they're an awkward group of letters to put together. And so when I talk about heirs property, I just say heirs property. And I'm not necessarily talking about the act and litigation, because a lot of the work that I do as far as the preventative education, but also when I'm advising clients, when I'm doing estate plans, and when I'm dealing with probate matters, is not in litigation. But instead it's before litigation, it's around the education. And, you know, I have multiple cases right now that are in litigation, and so I am talking about what is required under the Act and getting familiar with the Act in that way. However, in my practice, I think the real work, not the real work, it's all real work, but the majority of my work is not spent thinking about, you know, the specific requirements of the Act. And I think that that's actually a testament to how well the Act has done and how it's kind of changed the landscape in Georgia. So I look forward to talking with you all about that. Ashley.
Good afternoon, everyone. My name is Ashley Edwards. I am the founder of AAA Probate Resources. I am not an attorney. I come into this work really on the prevention of heirs property side. So my work sits right at the intersection of real estate and legacy and housing stability. So a big part of my focus every day is pretty much what creates the situations that we've heard about today and what you will continue to hear about as we move through the program. And then what families run into once they find themselves in an unclear ownership situation. But then lastly, what us as professionals and practitioners and institutions, what we can do a whole lot earlier to prevent so many people from kind of landing in the place where they need the help of UPHPA to combat some of their challenges. So I'm really excited to be here today and looking forward to our insightful discussion.
Well, thank you all for giving us that context on you. And now let's talk about some of the context around the UPHPA as we see it in Georgia. So as we mentioned, the law passed in 2013. And it's meant to promote a consistent legal process that aims to offer better protections to owners of heirs property. And can you, Sarah, maybe this would be one that you might be most interested in answering, perhaps describe the status quo before the UPHPA passed, and specifically what precipitated the passage of the UPHPA for Georgia?
So to help set the stage for what the world was like before the passage of the UPHPA in Georgia, I would just say that there were partition actions filed routinely that could dispossess a family of their land at far less than the true value of that land. And so the problem that this Uniform Act was intended to solve, and I think what galvanized people of goodwill to push for its passage in Georgia, was this concern with, firstly, the loss of land tenure for homeowners, landowners, for people of color, for all of the groups that are impacted by this problem, the dispossession of land, and also the loss of equity, because we know that that distressed sale price was one of the major problems, and really what incentivized speculators to go after these parcels of land was knowing that they could reap an enormous windfall if they were successful in buying out a fractional interest and then filing that partition action that they could then, they and their cohort or co-conspirators could acquire the land for much less than it was worth and take away, extract so much equity.
And so how does the UPHPA shift that? And Thomas gave us a bit of an overview,
Yes.
but let's give it some meat.
I will reiterate some of what Professor Mitchell said because it was beautifully said, and I just want to kind of re-hammer it home for folks who are newer to understanding the Act. Those three pillars are so crucial in shifting that power dynamic and shifting that incentive structure. So the first one being the buyout right. The fact that a partial owner who is sued in a partition lawsuit and facing the potential loss of their land has the right, along with any other co-heirs, co-owners, to buy out the party that is seeking the partition. So that buyout right, that ability to say, okay, you're trying to force a partition of this entire piece of land, we can buy out your interest. We have that right. And that way we'll be able to keep the land. The second piece being, of course, what I call the preference for partition in kind, but it's absolutely right to be more specific and say the consideration of non-economic factors so that a court can order partition in kind, the division of a parcel of real estate rather than the forced sale of the entire parcel is a very important protection. And then, of course, the third piece, which I would say in many ways is the most important and impactful, is requiring that the sale be through a process that is likely to lead to fair market value. So the appraisal and listing the home for sale through a regular public process as opposed to a forced distress sale, meaning that if there is going to be a sale of this property, it should lead to the heirs at least receiving their equity, at least not being dispossessed of all of that accumulated wealth. And so the evidence we've seen is that it has had an impact in Georgia in deterring that speculative activity and deterring any type of partitions, even if they're filed by a family member, but that could dispossess people of that accumulated wealth.
Thank you. And I think now I'd like to ask Whitney and Ashley, you have both worked with different households around either resolving or preventing heirs property in Georgia. What are the common household dynamics or gaps that often precede heirs property?
You go first.
Okay. So, well, in my opinion, I think that heirs property, a lot of people think that it starts with drama amongst the family. I think that it really starts with silence. The homeowner, didn't have a will, didn't have a trust, may not have felt comfortable talking about death and transition. Maybe some assumptions were made in terms of how that property or how they thought that property would transfer. No shared understanding as to who the decision maker should be. And so when you lack all of these things, you really put the property in an even more vulnerable situation. And so I think that in a lot of cases, when families find themselves in this unstable situation, they really, they're in a crisis, of course. But I think as far as some of the gaps that appear that really can address that, there are gaps in education or gaps in planning and how they should coordinate a plan. So as far as family dynamics, I really think that there needs to be more efforts put in place as far as families simply preparing for that transition.
Whitney?
Yeah, and I'll add, one of the reflections that I've had as I've been preparing for this conversation and just thinking about my work is the reality that many of the people that I'm seeing, that I'm speaking to, are owners of heirs property, and their families have owned this property for a century or more. They're also exclusively Black. Those are the people that I'm working with. And what that means is that for more than a century, in this Black American household, their family has held on to the land in Georgia. And what strikes me is how heartbreaking it is that the conversations in my role now as an attorney supporting them can't be around the celebration of that amazing accomplishment. Because in fact, their forefathers, their ancestors did create legacy despite literally everything in the way. I have one family that I'm working with now who are the first owners of this land of property in a wealthy county in Georgia. They're the first owners post-slavery. And now they're dealing with, partition. And I can't imagine what ancestors have gone through to keep that. So I think that is a common dynamic. This property is property that has been in families for generations. And that for a lot of Black folks, that is a source of pride. And so when we talk about knowledge and the lack of knowledge perhaps on what their true form of ownership is, it's common that people do feel pride in, quote, heirs property and being heirs property owners. They are proud, we are proud that we own this land, but we don't know that the legal term of art and what that means for the family and the legacy moving forward. And so education, that's why, although I can litigate and I can take these cases and whatnot, it starts with the education for me. It's something that I've had to learn about and understand and continue to understand. I did not get into this line of work without first finding a mentor, who I think she knows she's my mentor, because it's complex. So I think that's one of the dynamics that I just wanted to point out. Another, the generations, the lack of knowledge, but the role that a matriarch has in this niche area of law. Most of my clients and most people that we talk to, Ashley and I work closely together on preventative measures and education. We are speaking to women. We are speaking to women who are matriarchs of their family or who are the next generation matriarch. They will be the matriarch. And I think that's just an important acknowledgement as well. Women are carrying this. And I'm not a social scientist. I want to see the numbers. I want to see the data. This is a task. I want to know who owns heirs property. Is it the case that it's women who are now, obviously everybody owns heirs property. But, these families are families that are led by matriarchs. And we don't plan. We don't have estate plans. And what does that mean? I'm really interested in that dynamic. We care so much about our matriarchs. We revere them. We go to them for literally everything. For many of us, they're the reasons why we got into school or that we still have this home, yet we don't help them plan for their transition. I'm really interested in that dynamic.
Thank you. I think those are very important observations, and oftentimes the place of observation as an attorney or a caseworker working with many people, that's a privileged place where voicing those observations you make can make a big difference in the way that people see a problem and ask questions about it. So I really appreciate that. I'm curious, you spoke a lot about the rural land in Georgia. Ashley, do you want to provide any of the urban context? I know that is a lot of the work you do too.
Yeah, so from my lens, as it pertains to the rural versus urban settings, I kind of look at it from a broader view. I think that, yes, in the rural sense, when you think about large tracts of land, there may be more flexibility in terms of dividing that land physically if there's, 10 heirs on the property. In the urban setting, not so much, because you can't physically divide a single family home 10 ways. But in either case, you still have an asset that has fragmented ownership that is dealing with, layers of, because it's typically not just one cause, it's layers of issues that's impacting the family. So you have the fragmented ownership, you have the unclear authority, you have tax concerns, you have insurance and title problems and deferred maintenance, delayed repairs, and underneath all of those layers is grief. And so whether it's rural or urban, the family still has those same amount of layers possibly that they have to maneuver through.
Thank you for that appeal to the universal. It's very, very true in the context of this issue. Do you, any of you, see what the greatest opportunities for housing organizations, nonprofits, municipalities, lenders, real estate professionals? I mean, this work happens in many ways through many actors, or could and should, right? What opportunities do you see amongst the actors to support families earlier and help prevent heirs property situations, maybe from developing or further developing?
Okay, I can chime in briefly. I think we both know more about this than I do, but I'll give a small slice, and then I want you to add. I think this is something a lot of us have been struggling with, is how do we reach people and galvanize them to action when people are bombarded by so many demands on their time, especially low and moderate income families who are squeezed. And the reality of their lives is they do not have time to stop and do estate planning. And so folks have thought about, okay, should we embed this in the home purchase process, which I think is great to include some of this education and awareness building at that stage. I also think that's a stage where people are having to learn and absorb a lot. I'm not sure if they're also going to be ready to make an estate plan in that moment. So I like some of the ideas I've heard around home repair programs and senior services, like anytime, and sometimes those go together, senior home repairs, like please, let's talk about estate planning at that moment when we have a touch point. But I'm very curious what you all would say.
Yeah, I mean, I do think that having discussions about estate planning during the home buyer process, I do think that that is critical. It is the case that there's a lot going on during home buying. So yeah, what I've learned in the past several years of having a founding Wills for the People is that we need multiple touch points about estate planning. Very few people are you going to say, hey, you should get a will, and then they go get a will, right? That takes 8 or 9 or 10 or 11 conversations, and oftentimes it takes them having to deal with probating somebody's estate, unfortunately. So I think, I'm also thinking though about like, we can estate plan and create heirs property. There is a wrong way to go about leaving property. And so I think it's also incumbent on us as estate planning attorneys that when we are meeting with families, that we are educating them around how we're going to leave a property. That we are not allowing, I'm a private attorney, so I can say no. And when people say, I want to leave my property to these 5 people, I just say no. We have to come to a different agreement. We can do other things. You can think about a trust. You can, whatever it is. But I'm not in the business of creating heirs property if I, cannot do it. And so I'm happy to refer you to somebody else if you would like to do that. So making sure that our clients are understanding why, though, because they also need to pass the education on. And then also, I think that there's space for education on next generations around home ownership as well. Because with heirs property, a lot of families want this property to stay in the family. So they want somebody else in their family, the next generation, to own the family. My question is, has there been any conversation with that generation about home ownership? We talk a lot about home ownership for first-time home buyers. We don't talk about home ownership for people who are inheriting homes, who may themselves be first-time home owners, but they're not going through a buying process, or maybe they are because they need to assume a mortgage. So including that kind of education, that's something that we can do as estate planners when we maybe have a family meeting post estate planning, or that's something that the other institutions that are already doing that homeowner education can start targeting those groups of people who intend to inherit land.
Yeah, so for me, and I definitely agree with everything that's already been said, but I kind of look at it similar to what Whitney just mentioned. I look at it from two different angles. On one hand, you have, the traditional homeowner that literally raised their hand to say, hey, I want to become a homeowner. And they may have enlisted the services of a real estate professional or a mortgage lender. They, got an inspection done to make sure that the home was physically habitable, and an appraisal to make sure that, value matched what they were paying. And then they went and sat before a closing attorney to get further guidance as to how they can be successful in their home ownership. Whereas on the other hand, you have this inherited property owner that just became a homeowner overnight because someone died yesterday. And so they may not have ever spoken to a real estate professional or an inspector or a mortgage lender. And so all these touch points could be opportunities to educate, the community on how to be successful in homeownership. But as far as like those individual organizations, housing organizations, simply embedding estate and succession planning into already existing programming, so it doesn't seem like an extra, task. Or nonprofits normalizing the conversation around death and transition, or maybe municipalities and local governments thinking more about title continuity as they think about protecting units. Especially as it pertains to code enforcement violations and access to homestead exemption and tax relief. These are the kind of conversations that can be had throughout, as services are being provided. And then as far as like your banks and your lenders, they interact with clients and customers on a daily basis. So, their conversations can incorporate, hey, I see that you're the only person listed on your bank account. Have you thought about adding a beneficiary designation to your account? Or like a real estate professional, as you're out showing houses, you can openly talk about a will or a trust. It's not saying, hey, you need to do this, right now, but at least open the conversation up just so that your clients, as you're working with them, not, once crisis hits, but as you're working with them, these are all the opportunities or touch points where this, the conversation can be brought up.
I really appreciate you thinking about those moments of normalization because it's true. I mean, any estate planning attorney will tell you, people will call them intending to make a will, and then they won't actually do it for a year and a half, and that's just normal, right? And so having those regular touch points among everyone when they're interacting to normalize this. And Ashley, I particularly like how you give the details and sort of think about it in this 360 understanding of a life. And I'm going to tell everybody that I think part of why Ashley is so good at that is because she's also an artist. I mean, Ashley has created a whole documentary on heirs property, and in that work sat with many families that were dealing with the issue in depth, thinking about and thinking with them and listening to their journeys. And so I just want to honor that work that you've done because I think that it really, you give us such a grounded sense of this issue in our state.
Yeah, and if I could kind of, well, first of all, I'm not an artist, but thank you.
I think you are.
Yeah, that was such a fun project to work on, and part of what, and what she's referencing is a documentary that I created last year that Sarah actually was one of the featured experts in.
That's
but
right.
It's called Heirs Property, The Hidden Struggle, and it's on YouTube. You can take a look at it. It's not even 20 minutes long. But one of the points that I really wanted to kind of underscore in that is this whole idea of collaboration. You know, specifically in Atlanta, I could see that there's a lot of great work that's being done. It's phenomenal work. But a lot of that work is being done in a siloed capacity. So I'm working with my client from this angle, but my client has all of these other needs that I need you for, to kind of assist. So the whole idea of it was to just kind of shed light on the fact that, hey, while we're out there doing this great work, we need to be more collaborative and kind of coexist together to serve the people. Yeah, so
Well,
thank
thank
you.
you.
For that.
Can I just add one thing with
sure.
regard to opportunities that I feel like is an elephant in the room, and that is money. It costs money to have an estate plan that is drafted by a professional. It costs money to have a trust, and it also costs money to hire an attorney to litigate your case if a partition action has been brought. And so I have one client who actually did receive a grant for her family to hire an attorney to assist with title clearing. But what we're talking about people who are land rich, cash poor, right? And so there's just not a lot of money. And just to be very concrete, a will, $1,000 easy. You're spending $1,000 easily. A trust, you're spending $3,500, $4,000 easily for that and the rest of the documents. And that's in Atlanta, and so it's going to be different in different places. But I just think we have a lot of folks from nonprofits who are listening, who are in attendance today. And when I worked at Legal Services, which is where I started, I had no idea what the private market, rate was for estate planning. And so I just say that to say, we can't serve everyone in the nonprofit industry. We have to turn some people away. And when we are turning people away, they need to plan on spending at least $1,000, more likely $1,500 to get an estate plan in place. And that a lot of people don't actually have that. And that's for a will that still has to go through a probate process. They can go online, they can do the online programs and create a will for themselves, but I promise you they're creating heirs property when they do that. Because there's nobody there telling them, don't leave this to 3 people, don't leave this to 4 people, or describing what the difference between inheriting as a tenant in common versus a joint tenant with right of survivorship is. So I think that there is space for increased funding in this area for low and moderate income individuals who aren't qualifying for the legal aid programs to be able to hire legal assistance.
I appreciate that a lot. And we have spent a little bit of time here talking about that preventative step on purpose because it is part of the larger picture. I want to return to thinking around the UPHPA and sort of the context in which this law in particular arises in Georgia. So, speculative activity, both by third-party actors or even family members, has come up a lot as a critical force that catalyzes forced sales among heirs properties. I'm also thinking about the UPHPA in the context of what you just said, which is you need capital to move forward even with an estate plan. When we're thinking about buyout provisions, the first part of that word is buy. So we got to think, what does that look like, right? And so, let's first think about the speculative activity portion. What kinds of actors are involved? What practices do they take? What is the gain? Sarah, you've mentioned a little bit about this already. And then after that, I do want to think just briefly about that, how can people access the rights in the UPHPA, things like the buyout provision, if, in the situation that they are in.
Yeah. So I think to address this point about who are the speculators, they can come in many different forms. Real estate investing is big business. There is a ton of money to be made from these business models. And so there's an entire industry of people who see land as profit as opposed to housing and economic stability. And legacy. And legacy, exactly, right. And so these forces are out there, and it can be big companies, middle-sized companies, small companies, and many times it's difficult to know if the person who's the direct point of contact, is there someone standing behind them? Is there going to be an assignee, or is this a wholesaling situation? So but the big point is there are tons of these speculators, and they know that there is the potential for enormous profit from all of these tactics. And so that's why the UPHPA is so important. And just to say a little bit more about the impact that it has had in Georgia, you know, I believe there is evidence that the UPHPA has reduced the incidence of investors targeting heirs property for equity extraction. I wish there was more data, but I think the data that we have does support that, both through Urban Study, and there was an important study done by Betsy Taylor and Cassandra Johnson-Gaither and others that looked at Georgia and Alabama, a few places, and looked at partition filings. You know, it's difficult, the quantitative piece is difficult because many times, at least in Georgia, partition actions are not coded as partition actions in the superior courts. Yeah.
Right.
So
yeah,
it's hard.
So in like very localized practices come down to how it's keyed in the computer can really obscure the kinds of data that we'd like to be able to look at in order to understand impact more quantitatively.
Yes, but the evidence we have does suggest that investor activity has slowed, has been reduced, at least the ones directed at heirs property ownership. We know that investors also target other vulnerable homeowners and property owners. And we know that, and in terms of the buyout right, you know, you hit on something really important. It's a right, but can people actually exercise it? To do that, they need capital. They need loans. Typically, it's not going to be because they have to buy out this, whoever's filing the partition action has to be bought out at fair market value. What is their slice worth? And so I think the community who works on this issue has been trying to think about this access to capital piece, and we've seen Fannie Mae put out some blog posts about this, and you know, they will say, yes, heirs can get some types of Fannie Mae loan products, but the question is, does the credit box enable them to, you know, can they, you know, what about credit scores? What about income and ability to get through underwriting? So many challenges.
Yeah, I mean, my clients can't buy people out, is really just what it comes down to. And I don't know if they are eligible for the products that would, you know, provide them with the capital. You know, we have, Ashley and I are working on a case together where a person really got involved with what I would consider predatory lending.
Right. Because this is a position of potential vulnerability.
Right. In order to get the money to hire me. Right? And as, you know, I'm hopeful that it doesn't backfire. So I think that's, you know, I understand from the families. So let me back up to say that in all of the cases that I have or that I've worked on, it has been a family member who has initiated a partition action. There are just disagreements within the family, or maybe somebody just needs money. Maybe somebody needs money and they want to sell, they have an asset and they want to sell it. Cool. But then when it comes time for that buyout, there's not money to do the buyout. And so I just think that it is what it is right now. What I will say is that in all of these cases, you know, hopefully people are walking out with a partition in kind then if they can't sell. So the partition in kind is getting a piece of the land, getting a piece of the pie carved out for them, and then maybe they can try and sell it on the on the market. So I think that there's options for them, but I think, you know, this is one of the reasons why communicating with people about the UPHC about partition, you know, I don't get too technical about it because there are a lot of steps along the way that may be preventative. You know, they aren't actually accessible for that person and the outcome. So it's also about helping people with expectation setting around what is the possible income. Like if you don't have $20,000 and you can't find $20,000, then more than likely you're going to have a slice of the land, and then we'll see what happens.
And I'm so glad we're surfacing this issue. I think it might come up in a later panel when a powerhouse named J.C. Fisher, who runs around trying to scrape up funds for her clients to be able to exercise that right, will have, I'm sure, a lot to share. So we'll just foreshadow. This is sort of the Georgia context. J.C.'s in Alabama, so. Okay, well, I think we should talk now about really, these cases and Georgia. Are we, kind of this question, are we ready? What is our readiness in this context? Familial property disputes often take place in local courts where decisions of judges and status quo procedure can dictate outcomes. We're 13 years in, and I'd like to hear a little bit about, where are you seeing UPHPA in those courts, not just in the courts, but the legal infrastructure in general, other attorneys, knowledge base. Are legal actors in Georgia equipped to handle heirs property cases generally? And I understand, like, we've talked a lot about the prevention, and I know you've talked a lot about the efforts to build that up. And I want to think a little bit more about the actual partitions, the Uniform Partition of Heirs Property Act.
Yeah, I mean, I would say by and large, no, that legal practitioners are not prepared to handle this type of case. I'll say for myself, I've been practicing for 13 years, spent 7-8 years at Georgia Legal Services doing a wide variety of cases, some including property law, landlord-tenant, and it's kind of like I had an awareness of heirs property. But I did not have an awareness of a solution. I saw clients going through some things, but didn't have words for them. And I think in order to learn more about the solution, it took a deep dive. It took me seeking out a mentor. After I asked one of our local nonprofits if I could pro bono on a case with them, and can they teach me, and they said no. Because they don't have the resources. Nobody has the resources for this, for training while we go, and I totally understand that. So I know that there are resources available for the legal profession to be able to learn and to be supported once we are in a case. But this is an area of law where I wasn't going to get involved without having somebody that was going to be helping me. Like without somebody that I could pay for your advice on how to do this. I was not going to feel comfortable with that. I didn't go to school in Georgia, but I don't remember learning about heirs property and property law. I really had very little concrete, real education later in my legal career.
Any other thoughts on the readiness in Georgia, the infrastructure?
Yeah, so again, I'm not an attorney, so I'll leave the legal analysis to you all, but from my lens, it really kind of goes back to vulnerability, how vulnerable the family is. I wanted to touch on the fact that in many cases, the legal system is typically inheriting problems that started long ago, before it even reached the courtroom. I think if families aren't educated on these issues until after somebody died, then it's too late. And I don't believe that a courtroom should be the first place that a family learns that ownership after death required, past tense, a plan. That it's just not the place. And so my background is real estate, and I've been practicing real estate for 15 years. I didn't learn about probate and heirs property and estate planning until I was in a situation where I had to learn it. It wasn't information that was, willingly given to us, not through, pre-license, not through any post-education courses, and then I went on to get a broker license, and I don't say that to brag. I say it really out of conviction that, you know, I'm holding this license that is helping people purchase probably the biggest asset that they'll ever purchase in their lives. But if I'm not also educating them on how to keep it, then I'm really doing them a disservice. And so when I sell this individual this house, and then they pass away, now, and they created heirs property, now it becomes a bigger burden for our legal system. And so these are problems that really can be combated long before they're acknowledged as a problem.
Thank you. And I do want to just mention what I think of as just, as a real bright spot, which is my understanding that the Georgia State School of Law, Georgia State University School of Law is actually going to be opening a heirs property law clinic. Oh, wow. And I think I and maybe my little cohort in my class were lucky to even have heard of heirs property when we were in law school. But now, there will be a lot more opportunity at least for the students at Georgia State University, which is quite exciting, I think, for the prospect of building both an attorney pipeline to build this and also just attorney base that understands what the issue is and maybe has touched it even before they got their license. So that's neat. And I think now, well, actually first, since I just gave a solution that I've heard of, I'd love for you guys to just, if you have any thoughts around policy or otherwise that can help strengthen the goals of the UPHPA in Georgia. Are there learnings from other states that can be pulled from? Just your own original ideas, more documentaries maybe?
So I like to think about this issue a lot. What are the next steps? The UPHPA is such a fundamental, important piece of protecting heirs from a number of risks, but there's more. And as Professor Mitchell said, this is addressing one problem, but there are many problems and challenges facing owners of inherited land. And I actually really liked Professor Mitchell's description of preventative, curative, and adaptive. And in NCLC, the adaptive bucket, the way we describe it is policies that protect heirs property owners from the risk of loss, because we know that these properties are vulnerable to loss. And so one of the major things we're trying to focus on right now at NCLC is reducing the risk of property tax foreclosure for owners of heirs property. And we know that at least one study out of Texas by Heather Way showed that 50% of the residential properties in tax foreclosure were heirs properties. And we know that heirs property owners are most likely not going to have the tax relief that they are legally entitled to, which is the homestead exemption, or in some states it goes by another name. But whatever your owner occupant tax relief is, heirs property owners should have it because they have a present ownership of this property, and if they are occupying it, they should get that tax relief, but they don't because the systems in place do not allow them to get it.
In Georgia, they do
in
not,
Georgia and in many places. And so allowing flexible proof of ownership for getting that tax relief or for getting home repairs, these are major, and disaster relief is another one.
Oh, absolutely.
Truly important policy changes that we need at the state and local level.
Yes. And actually, could you speak just for a second, in case there are folks in our audience who are unfamiliar about what that tax the property tax situation looks like for an heirs property owner? So somebody's maybe come into ownership, maybe grew up in this property or in this home, and the matriarch, perhaps, as we've discussed, has passed away. What does that look like?
Right.
What do they feel like?
So I think that, and Ashley does such a good job reminding us of this and has alluded to it, that first of all, they're dealing with the grief and they're dealing with an enormous number of things that have to be dealt with at that moment. And then the property tax bill will at some point go up because the counties are checking the death rolls, and they realize that when someone who had the homestead exemption has died, they see that and they remove the exemption. The problem is there is not a simultaneous effort to communicate with whoever's living in the home and may be entitled to the homestead exemption. So there's this communication gap, information gap. And so those heirs, whoever's living in the home and has an ownership interest, their tax bill will skyrocket. It may double. And that puts them at risk in all states of this very fast process that can lead to a distressed sale, an auction of the house.
And oftentimes there is a speculator at the other end of that sale.
Absolutely.
So there can be pressure on these. And unfortunately, those heirs owners do not do not get to benefit from the UPHPA protections
Right.
in that context because they're not in the midst of a partition.
Exactly.
Yeah.
It's a different threat that
Yeah.
requires a solution.
Yeah, well, I appreciate that. So I think, do we have time for questions? But that was just for the, okay, I just wanted to make sure we are on. I think we'll move on to some of the questions that folks have submitted. How do you guys feel about that? Is there anything else in our main discussion people wanted to add before we do that? Ashley?
Yeah,
Yeah,
just one
please do,
thing,
yeah.
in regard to the strengthening, as far as us thinking about how can we strengthen the goals of UPHPA, I think we really need to, we really have to consider where we are now. And I don't say this to sound morbid, that's why I'm kind of thinking through my words here, but baby boomers across the nation are the highest homeownership population. Baby boomers are those born between 1946 and 1964. So the oldest baby boomers are approaching their 80s now. So in the next few decades, we are going to see a great wealth transfer. We know this. So, like we're in rooms like this having conversations like these, and we have these conversations daily, but the average person is not. And so because we know that the average person is not, and because we know what the next 5, 10, 20 years is going to look like, I think that as we are, preparing our housing strategies, or as we're talking about housing stability and affordable housing and preservation and prevention, all of these, housing terms, or, in some cases legal terms that we use, as we're thinking about those things, then we also need to consider what the next couple decades is going to look like. And if our housing strategies and our plans or our business plans, if it doesn't account for death and transition, then it's really incomplete. Because one thing's for certain, two things for sure, 100% of the homeowners, baby boomer or not, will one day pass away. And so as we're having conversations like these, just thinking more forward as far as some efforts that we can put in place to combat some of the issues that we know are coming.
And there we are, death and taxes. Not to make light, I made light, okay. Thank you very much for adding that, Ashley. It's true, and actually I recall this exact room being here for a prior urban event where we were talking about that massive wealth transfer and the implications in the heirs property realm not long ago. I think that was one of Michael's prior, there you are, one of your prior works. So thank you guys for lifting up that issue as well. Let's dive into some of these questions. Yeah. All right. Oh, I like this one. I like them all. I've just only read the first one. How can local governments best support efforts to address heirs property challenges? And I know that we've all actually been present with folks that are in the city of Atlanta trying to think on this issue. So maybe we could draw from that. There's also opportunities around the state that have arisen.
Well, we should give props to the city of Atlanta, for example, that they are seriously engaging on this issue. And there have been working groups led by LISC Atlanta and others to pull together the stakeholders and try to talk about this and real focus on it, which is great. I do think, and I already talked about property tax foreclosure, but I've got to say it again, that is such an enormous risk of loss. And when it comes to what local governments can do, I think there has been more emphasis so far on the estate planning and awareness raising, but local governments' policies are leading to home loss when it comes to tax relief and tax foreclosure. So we need that to be a real focus of our policymakers, both in the Atlanta metro area and all of Georgia and beyond.
Yeah. Any other thoughts, local governments?
No, I mean, Ashley has worked a lot with local governments. I mean, I'll say a lot. It feels like a lot. In terms of being a consultant to be able to educate folks. And so I see that, like, in East Point, the city of East Point, for example, they had a wealth building festival, which was cool. And they had a part 1 and a part 2. And in that festival, we talked about estate planning, to your point. And so I also agree with you that there's, I don't see a lot of effort going on the back end of resolution. I see some effort going towards prevention. And so, yeah, I think you raised some good ideas.
Yeah, I agree with what you all said. I think I kind of touched on earlier Just, from a local government standpoint, this whole idea of code violations, particularly for inherited property owners. I think that there's, just not separating the type of homeowner or maybe the guidance that homeowner might have received. Inherited property owner is just as responsible for taxes and maintenance and insurance and decisions around home ownership as someone who willingly purchased their home. So local governments being more mindful of this population of homeowners that don't receive the same guidance.
Thank you for those ideas. Okay, here's a good one. What are some ways to reduce the cost barriers for estate planning and addressing tangled titles more generally?
I mean, the obvious, we could lower our prices, right? I mean, I know everybody's thinking that. Unfortunately, I got bills to pay, right? Like, nobody's thinking it?
Nobody's thinking that. None in this audience.
I mean, I'm always very transparent and forthright about prices because what I want for people to know is that estate planning is an investment. And the same way that we plan for vacation is how we need to plan for estate planning. Some people can't afford to plan for vacation though, so like what about them, right? And I don't have a great answer besides like I am a firm believer of social services and support and utilizing some of the free wills clinics. There used to be Black Women Will in Atlanta, which is no longer to my knowledge, unfortunately, because of we all know why. So, but there are still, the city of Atlanta has clinics, Atlanta Legal Aid has clinics, Georgia Legal Services has clinics. And so if you are someone or you know someone who is over the age of 60, who owns a home, I encourage you to encourage them to look into some of the resources that are available to them. And for others, I am not above encouraging pooling resources to support the matriarch in the family. My business supports matriarchs, and I think that we owe that to our matriarchs to pool our monies to be able to support them in true recognition that by supporting them, you're supporting you. Anybody else have ideas? I don't know.
I have one point to add that I think can be really helpful to this affordability and also the ease on the back end, and that is transfer on death deeds, which we do have in Georgia. It was passed in Georgia in 2024, but there have been some problems with our law in which there's this cumbersome affidavit requirement that so a transfer on death deed is a means of conveying land to your heirs, your intended heirs, without the need for them to go through the probate process. It is a deed that takes effect upon the death of the grantor, and up until that moment it can be revoked, modified. The grantor, who's trying to do estate planning, has full control to sell, mortgage, change the beneficiaries, but then at the moment of death it is automatic and there is no probate required. Because in all the outreach that we've been doing about estate planning, and if we're helping people create wills, they are going to have to probate that will and to find and serve all of the heirs at law. And so having a transfer on death deed is an extremely meaningful thing. The Georgia statute needs to be clarified, and there has been a bill working its way along that's not perfect, but that I think is going to make it better. But the interesting thing is, so 34 jurisdictions in the U.S. have transfer on death deeds, but largely not the states in the Southeast. So North Carolina, South Carolina, Tennessee, Kentucky, and Alabama do not have statutory transfer on death deeds. Florida doesn't have a statute, but they have a common law ladybird deed that works fine, so they're fine. But we have all of these states in the Southeast with tons of heirs property and risk of heirs property, and this would be a low-cost way of preventing further creation.
Thank you for naming that. Sarah Mancini, this question is for you.
Okay.
When partition actions are not coded as such, how are the researchers that are looking through the data decoding that? Are there any obvious signs that something's actually a partition action?
So I think it's difficult, and we did talk about when Urban was starting up this work, we were trying to talk to various attorneys that work on this in Georgia, and we determined, okay, well, they would be filed in the Superior Court, which is our trial court of general jurisdiction, and it would probably be like other civil, so clearly it's a civil case, but there's no other coding. And now, so this could be an opportunity for reform, right? We could change the court rules or the court forms, the case filing cover sheet to check off if it's a partition. That would be good. I think as it is right now, you would look at all civil cases one by one. And I don't know whether some technology could help with that. But I think, you know, for one thing, I don't know if they flag them as being related to real estate in all cases. I'm not sure. I think it's a tough problem.
Yeah, the only thing I could think of is maybe if there's like a lis pendens that's filed, but that would just refer back to the case.
Right,
I don't
and
think it would-
that's not
so you'd
always
still
done.
be having to scrape the text of the filing
of the
itself,
complaint,
looking
yeah.
for the code, probably the code
section,
section.
yeah.
As it's cited, cited. So whoever you were, there you go.
Yeah,
That's your,
it's hard.
it's your
And
project
I
now.
think, like, the other thing that I'll say too is the
Oh, yes, Whitney.
the partition that happens in probate court. You know, not under the name of partition, but when we are representing people in probate court and heirs are inheriting property, they have an opportunity at that point to basically waive their right to the property.
Yes.
And this is, you know, a partition in type, maybe not in the legal, you know, terminology that we're using here, but it is a maybe divesting of a property interest and kind of pooling of a property interest. And so I do think, like, these are people who don't have to get to a partition action in court, but who are still, in fact, heirs. They're owners of heir property, and at that point, they have an outlet for dispensing of heirs property if they want.
Yes, and I think there's a whole conversation about probate practices that are parallel to partition and all of these sort of property loss scenarios that we didn't even have today. Let's see. Sarah, I know that you can answer this question, and perhaps both of you as well. I just worked alongside Sarah as we both dealt with this. Has anyone had success in dealing with mortgage companies for encumbered heirs properties? We frequently face numerous issues with mortgage companies' successor in interest policies.
Yes. This is one of my favorite topics, so I will take a stab.
It's just like written for you.
There are important rights under federal law that people have if they inherit a home subject to a mortgage. We call those people successors in interest, and the rights are under RESPA, the Real Estate Settlement Procedures Act, in rules that were created by the CFPB, Consumer Financial Protection Bureau, that took effect in 2018. So there are important rights. Unfortunately, those rights are often violated. But those people who inherit those homes subject to a mortgage, they have the right to be confirmed as a successor in interest, and then to get mortgage statements, to apply for loss mitigation if they need a loan modification, to dispute servicing errors. Unfortunately, there are a lot of problems that still happen, and having access to an attorney makes a world of difference because a lot of mortgage servicers are still not following the rules. Is there anything you want to
No, I mean, this has been my experience.
Yeah.
A second?
I just tell, consult with an attorney, because I've seen situations where the heir, the owner now communicates with the mortgage company, and the mortgage company cuts off all communication and don't continue to accept payments. But then I've seen the other side where, hey, if somebody's paying, we'll take the money, you know? So I always say consult with an attorney.
Yeah.
And that should not happen. Cutting off, you know, stopping taking payments, all of that is illegal on multiple levels, but it happens.
So we only have a few minutes left, and I'm debating between the two questions that are here. Let me think. I'm going to go with this one. Even within the state of Georgia, it seems that households can have different legal experiences based on where they are located and the structure of the county courts and assessors. I think that's come up. How do you deal with providing legal and/or planning assistance within that local variation? And I'm really thinking, Whitney, about your work, and I mean, I happen to know you're a mentor, and there's work all across the state. You are working in, and she are working in many different jurisdictions. Can you talk about this local variation and how you manage it?
I mean, so practitioners in every court in Georgia struggle with this because there's 159 counties in Georgia. Probate court, which is where I'm primarily practicing, unless it's a partition action. I mean, it's kind of, they do what they want. And it is challenging. What I have tried to do is establish contacts with attorneys in that locality to be able to know what to expect, to be able to then advise my clients. Or I have my wonderful legal assistant call and try and make friends with the clerk's office and ask questions, play dumb, because truly we don't know. I mean, it's as simple as we don't know if we're supposed to serve the parties or if the clerk's office is going to serve the parties with whatever the documents. We don't know if we're supposed to pay the fees ahead of time or if we're supposed to pay the fees after. And when you don't pay the fees in the order that you're supposed to pay them in, the entire case is delayed. So this happens in every court throughout, and it is a challenge. On the estate planning side, I don't see that same challenge because when we are strategizing around your legacy plan, like where geographics come into play for me is your executor or your trustee local in Georgia? Can they afford a flight out to Georgia to administer your estate? It's not so much about, how the court is going to deal with your will, because we don't even know where you're going to be when you pass away. So it is a challenge, and trying your best to become familiar with whatever court you're practicing in or to make friends in that jurisdiction has gone a long way for me, because I've definitely called people to be like, so this court, what am I supposed to do here? So, yeah.
And any other thoughts around local variation? I mean, I think this is really a true thing about the Georgia context. 159 is a big number.
And it probably does point to the need for transparency and information, from probate courts, from all of these different systems that we have to interact with.
And I'll say that when you ask, they are transparent. That's the great thing. Like it hasn't felt like information is being kept, at least from me as the attorney with power.
Yeah.
I'm sure from a pro se litigant, it probably feels pretty different.
Yeah.
But clerks are used to people calling to be like, how do I do this? Particularly in probate courts, less so probably in superior courts, but probate and magistrate courts in Georgia are like the people's, courts, if you will, where there's a lot of unrepresented litigants. So.
Well, I just really appreciate all of your willingness to, all y'all's willingness to.
Georgia.
I'm not going to swallow that.
We're the South. So
That's right.
We know what you mean.
To try to shed some light and really give context to the state of Georgia's experience with the UPHPA and all of the other issues, maybe not all, but I don't think we got to all of them, but many of the other issues that surround the issue of heirs property and the families that experience it. So thank you all for being here.
Yeah.
Let's give them applause. Yes. And I want to introduce or hand the stage over to Michael Neal and Ryan Thompson, who will be having a fireside chat about social sciences research in the area of heirs property, of which they are both experts.
Using my microphone.
Thank you.
I will say a couple things. First, I will introduce myself. My name is Michael Neal, and in this role, I'm a senior fellow here at the Urban Institute. It feels good to be playing a home game. I have given presentations in other places, and sometimes I just feel most comfortable in the confines of the Urban Institute. So in that way, I am eager to have this conversation. I'm sitting next to Ryan Thompson, and I have had the pleasure to know him and his work and to learn about it over the last, year, 18 months or so. I'll tell you, when we first started doing this research, about 2 years ago or so, and I want to thank my colleagues, J.P. Walsh and Matthew Pruitt, who are in the crowd, Emily Zinn, who is not with us anymore. She's now in a graduate program at USC. Thank them for their work supporting the research that we've done in this area. But when we first, started doing this work, I thought, wow, we're really kind of on the cusp of something. And in that time, I got invited, this was probably this time last year, got invited down to the Atlanta Fed. Sarah Stein was just up here, up on the stage. And Ryan gave a presentation on his research, looking at how it has grown from its beginnings 20 to 30 years ago. And one of the things that he pointed out very clearly, the takeaway that I had, was that it was really kind of the urban-focused research being done at nonprofits that was the newest research. And for me, that was an aha moment in terms of I thought that we were really on the cusp of doing something novel, and Ryan tells me, no, you guys are actually a couple decades late to the game. So that has been kind of the way that has always informed, I think, my posture to this work, and really trying to listen and to learn to those that have been doing this work much longer than I have and that we have. Now, let me just start, number one, by introducing Ryan. I've introduced myself, talked about myself, but Ryan, associate professor at Auburn University. I can say, newly associate professor. So, hand clap, reaching tenure. Obviously, we love to see that kind of success happen. So, congratulations to you. And I'm just going to start off with, continuing further introducing yourself, talking about, how did you get into this work? What was that topic early on, and how that kind of evolved?
Yeah, thank you. So it's an honor to be here today. Coming from Alabama, Georgia did a great job representing the South. Thank you. We definitely have a unique culture down South. It's something that's hard to articulate in a way that actually represents it. But I'm a sociologist, so I get to professional people watch in the Deep South. And 10 years ago, I started my dissertation. I was working with the Gullah Geechee Nation and jumping between sea islands and the low country and back and forth. And one of the younger, recently returned Gullah Geechee lawyers says it's all heirs property. They're coming for all of it. They're going for that one for 5 mil, that one for 10 mil, and they're picking us apart. And they put up a fence, they lock us out. And I admit that I heard heir property, thinking heir as well. So biggest change in my career path, and I misheard her. But I then deep dived it. I started looking at it closer and arrived in Alabama, started doing a little bit more of this work, and found people living in big box store sheds, the ones you would buy and just drop in your backyard, because they wanted to stay on their family land and stay near everyone they loved. A quote I oftentimes heard was, "Everyone I love is an earshot." And they didn't call it heirs property, they just called it family land. And it was just this naturally occurring phenomena among certain pockets, and it takes a lot of different appearances, but it was definitely ramping up more than I was accustomed to once I arrived to Alabama. Only years later did I come to conclude that, depending on how you measure heirs property, Alabama, Mississippi, or Georgia is number one in that, in terms of its total acreage, total parcel value, total market value. So it's been a career trajectory to move towards this, and it's pretty much become my obsession since then.
And, that certainly is a story that we've heard, before. I think Professor Mitchell talked about kind of how he came into this work, and, also discussed some of his recent scholarship, kind of documenting the field. And I want to ask you to kind of pick up on that in terms of, where did we start? How has that evolved? What are the research perspectives that you're now seeing? Let me just kind of stop there and let you take it.
Yeah, so Thomas did a great job summarizing kind of the early legal origins of the movement, if you want to call it that, or the larger effort to address and name this phenomenon that didn't even have a name, it seems like, when it all started. But going way back to the Emergency Land Fund, we see that there's a long tradition going back 50 plus years, and it really originated in my mind with the Federation of Southern Cooperatives Land Assistance Fund. This is Black Ag championing land loss. And we had known the USDA was tallying that black land loss was dropping 89%, 90%, 91%. It has rebounded a little bit in the last few years, but there is this plethora of research. And looking at the larger spread over time, the Emergency Land Fund was their first study. You see a few other lawyers kind of coming in, and then you see the arrival of the HBCUs. The historically black colleges and universities really joined the game sometime in the early 90s. I have to shout out Robert Zabawa at Tuskegee. He's kind of one of the godfathers of this work. Been doing a lot of the anthropological grassroots level work. And then the white land grants really start to arrive around 2005, 2008 with Connor Bailey and others. You also see the legal arrival. Thomas, I think like 5 of your works are on here at different time points being referenced in different categories. But in looking at this, we see kind of 3 or 4 different traditions coming together. And this ebb and flow, if I can summarize it this way, there's 3 different eras. The first 45 years was trying to say, hey, heirs property is a problem. And we did a lot of work. There's great documentaries doing this, Gaining Ground, Al Roker, Silver Dollar Road. And now that we know it's a problem, I would say the last 8 to 9 years has been quantifying. There's been this huge push to try and figure out how much is it worth, how big is the problem. And I think we're leaving that phase now and starting to enter a new era of so what? We know it's a big problem, so what is the impact? So what is the immediate impact on the ground?
Let me come back, because you bring up a good point around kind of sizing the problem. And certainly, you know, a growing number of pieces. I think Professor Mitchell had a slide early on with a few examples, including, you know, one that you've done. You know, we at the Urban Institute used the Health and Retirement Study as a way of trying to size the risk of tangled title. But can you talk a little bit about, you know, what are some of the challenges around kind of understanding the extent of heirs property, and what are some of the learnings that we might have gotten from this particular phase of the research?
Yeah, I get a lot of calls, like hundreds of calls. Hey, help me find heirs property. Just tell me what number or name to look under. And I kind of laugh because the United States doesn't have a standardized tax nomenclature system. It can be under one of 8 classifications. And I started with 5 lines of code, and now it's at like 217. And it changes by state, and it changes on preference, and it changes by year. Some indicators work here, don't ever use that there. It's a landmine game where you figure out, okay, don't step there, this works instead. And what I think we're starting to see is that this quantification effort, while definitely warranted, needs to be ground truth. So I can, and in 2017, Cassandra Gaither-Johnson and her colleague Pippin published their famous now study that found you can use secondary mortgage databases to find heirs property. And that's what I really relied on during COVID when I got locked in and couldn't do interviews. And now that we're coming out of that, we're coming to realize that there are definitely gaps and errors within it. It wasn't until talking with a tax appraiser this past summer where he goes, oh, the predation was out of hand. We made up our own shorthand code that nobody knows. And it doesn't exist anywhere else in the country. And he says, I'll tell it to you if you promise to help the people. And so we did, and as a result, it was all right. I mean, thousands and thousands of cases hidden right there. And if a tax assessor has the power to hide it that way, how many tax assessors are you thinking about in the United States have the ability to use their own classification scheme, their own structure, their own nuance? And so trying to do a one-shot fits all for the whole country, I don't think is actually the strategy anymore. We all have our estimates and large numbers, but we got to ground up and build from what we know.
And, you know, part of this has come out of almost a research to action kind of heritage of, you know, practitioners, maybe policymakers who, you know, are now interested. They're learning. They're understanding the problem. They're being introduced to it. Something that we heard in the last panel, and now want to know. Well, how big is it? And the reason I ask is because that research to action piece I want to push on a little bit more, specifically around UPHPA. And what have you seen? What has been the impact of UPHPA in terms of what you see as a trajectory of the research?
So the UPHPA created the backstop that has made so much of this not a nightmare. I mean, we now have legal provisions and protections in place to help people from heir hunters, from predators, and that's been absolutely huge. Alabama was the 4th state to adopt the UPHPA. Georgia beat us, an SEC rivalry. But nevertheless, this effort, I thought it was the end-all be-all, the holy grail, we have it. Now we can protect everyone in the state. Turns out not all judges even know of it or use it correctly. So you have the provision in place, but if you don't know to throw the flag that your property rights have been violated, that there was supposed to be advance notice that was violated, that the right of first refusal was completely omitted, I think researchers are realizing that looking at just large-scale quantitative isn't actually making as much change as we had hoped. So I think going back to that grassroots, the arrival of the nonprofits, the arrival of this type of work, I oftentimes just spend a lot of time hanging out with lawyers, Fran Miller, J.C. Fisher, and I'm not a lawyer, take everything I say with a salt mine. But I've learned a good bit in terms of there are patterns to it. Yeah. And if I can discern some patterns from them, I can develop better research questions to hopefully help arm them with the knowledge they need to move forward.
You bring up an interesting point, and certainly it suggests that a part of the research around the genesis of the research certainly might have been concentrated in the legal field, but what I'm hearing is the potential for more interdisciplinary kind of work.
Yes, we have, so 10 years ago, it was a handful of familiar faces on all the same calls, repeating, and now we have 4 networks in the hundreds each, all working on some different facet. HPPN, Heirs Property Practitioner Network, being my favorite. But we also have SARA 49, which is a multi-state project for the USDA, where now land grants and professors like myself and extension agents can consider this working on our projects. We can make this a part of our job. And that changed the landscape. So then the Southern Rural Development Center went around and we started training extension agents. Now we have 600 extension agents doing this work in every rural county in the Deep South. So we've come miles in a very short period of time. I do think that there's a few groups maybe missing from the room. So the economists are slowly coming in. You see DeSoto and kind of the classic Deaton stuff. But beyond just productivity, the finance side of this whole thing, how do we keep people, family in their houses? Anthropologists talking about stories of place-based attachment. Sociologists are very much present, but I think we need to maybe consider people like social work. How do you untangle a family fighting over a property that got stuck 150 years ago and now has 92 heirs, and out of the 92, 14 can't be found and 16 won't even talk to you. So how do we do that? I think it's a new era of questions.
And that's a heads up for those of us in the Housing Finance Policy Center, that there are opportunities. But second, it really echoes, I think, a lot of the things that Ashley said on the first panel, in terms of those family kind of interactions, and what are the research and systematic frameworks we can use to understand them as researchers. Let me ask. I mean, you've done some work to dispel some of the ways that we think about heirs property, and I know one of the things that we've talked about, and I've heard you say, is there was one way you thought about the world kind of in the beginning, but as you have continued to deepen your knowledge and research and engagement, your thinking has changed a little bit. Can you walk us through that?
Yeah, it definitely has changed a lot over the last 5 years specifically. First, I didn't realize that this is a historic, long-running process, meaning that I was in the National Archive last summer here and actually found a map that said heirs of on it going back to 1695 in Massachusetts. Heirs of has been happening longer than the United States existed. Our legal operating system is predicated on 16th century English law, and we've just been updating 1695 windows here, hoping to get some kind of new release. I would take XP at this point, and that says something. but we're not changing the operating system. It's just plugging gaps where we find them in hopes that the system keeps running. And so I no longer think of heirs property as this monolith, as this like single thing. I know it when I see it. If anything, there's three big myths that have just completely gone out the window for me in the last few years. First is that it's a black problem. It's championed by Black Ag. It must be a largely black problem. I agree with Thomas's comment that I actually think the bulk of heirs property in the United States is white. Majority of the land holdings are white. Many of the people we get calls from are white. And this is Alabama. So that was the first one. And then in that same vein, that it's a poor person issue. I know millionaires who have heirs property. I can find it in the richest neighborhoods in the United States. If death happens without a will, you have it. So getting away from this, oh, it's a poor black problem, to all races have it, it cross-cuts class. Although patterns do concentrate in some areas, I definitely think we need to undo that way of thinking. The second myth is that it's caused by ignorance or some kind of bad decision. In many situations, I see that people actually made this decision to let it ride under a clouded title intentionally, whether it was due to distrust of the tax office or county officials, whether it was a nightmare story and they knew why not to do this anymore, and many just taking the words of the elders who passed on the idea that leave it clouded, that way anyone can come home to this homeland. There was no, oh my gosh, you made this terrible decision. You made the decision that was best for you at the time. I'm not an economist, so I'm not going to claim that rational choice dictates the day, because my family is definitely not rational. But nevertheless, there is a calculated thought process at play for a lot of these families. And so the third myth that I've been working to overcome is that heirs property necessarily means blight, neglect, and dilapidation. And a little bit later in the talk, we'll definitely return to this, but many heirs properties are maintained and sometimes more valuable than the clear property titles in that same neighborhood. And that's because they're being maintained directly out of pocket, a lot of maintenance just going more frequently, smaller revisions. But these families haven't given up. And I think to assume that all of them blight it and leave it behind is actually done more detriment than good.
Very powerful, because oftentimes, even as researchers, as much as we try, there are priors that we have coming into the work, or even a set of stylized facts that, past research has suggested are true, but deeper questioning, which is kind of what we're tasked with, may unearth that, in fact, this is not the case. So really appreciate you bringing that up and just asking us, I think, to even ask ourselves, are some of the foundational views that we've typically have always kind of walked around with, are they true for everyone all the time? That first kind of set of questions really kind of focused on, the overview of the history around heirs property. But we want to kind of take the next step toward a set of questions that are really focused on, what should the research look like moving forward? And so these questions are really kind of in that vein. And let me start off just by saying, you've given us a wonderful description of what has been done and who has been doing it. But where do you still see some of the gaps?
Definitely. There are lifetimes of work to be done. This is a co-citation summary of heirs property research. The different colors or the different disciplines kind of talking to each other. Sorry, I'm the team's data geek. Of course there's going to be too much data. I think that we're seeing some new gaps emerging from that practitioner community-based approach. And as long as the lawyers will let you hang around, or tax assessors, I highly encourage it, because they just ask radically different questions than what I would ask. And so if you're willing to give over control to lawyers or someone who's on the ground doing the work and concede the questions to them, it opens up a new door of what you might be able to do. And so if one of the heirs property practitioner networks say, hey, where's the biggest impact I could have? If I'm going to do 3 events at churches, where is that going to be? Well, not only am I looking for heirs property hotspot, I'm looking for churches with trust. I'm looking for social capital that can be leveraged into getting attendance out. I'm looking for a community that's holding on but isn't tipped yet. It's not too far gone. It's not all the youth migrated out the brain drain. So we're looking for different features, and I think social science can do that well. and looking at this crazy map here, I definitely think that there's been some shifts in terms of how we do the work. Since we went so hard into the quantification phase, I think we moved a bit away from that interview, the qualitative focus groups with families. Man, I learned more talking with many families than I do from, forgive me, I'm trying to read your law articles, but it's a little too much Latin for me. But man, a family can summarize that exact same experience in a radically different way. And so I kind of want to go back to that qualitative, grounded human experience. And JC and I were at a signing event where everyone got their deeds back. And the minute they all signed their property over to their descendants or got the title cleared, they started crying and then wanting to tell their story. And I think that that is a part that I want to do. We've heard death by heartache a million times. I can't do that anymore. It's too depressing. Yes, it's tragic. But what about the ones who won, who fought back against all odds, no money, no nothing, and still came out? So it was strong families, a willingness to work with legal, a willingness to learn, a willingness to take the family Bible and figure out who's on the tree as fast as possible. I think that kind of work is actually what I find more meaningful today.
Yeah, I mean, that's something, you know, in some of the work that we've done here and that I've done here at the Urban Institute, kind of shifting to that more asset building approach as opposed to a deficit approach, I think has required me, has been a paradigm shift for myself. And so I appreciate you bringing that up. I want to ask a question about data, but just before I get into data, let me just piggyback on a question, on a statement that you made around the qualitative work. And do you see an opportunity for maybe the qualitative work to help to inform some of the theory?
Definitely. I think we need almost like a oral history to see if we can start picking up on some of these patterns. Because like it was mentioned on the previous panel, people are getting older. The land transition's happening faster and faster, it seems, by the day. And they have stories, they have place-based attachments. I was interviewing one man down in Florida not long ago, and he talked about how that tree is where his ancestors got their freedom when the Union Army came through. But had he just signed it to the grandbaby as he went into hospice, that story would have been lost. And so how do we help maintain these attachments and these beautiful stories? I think it's a gasoline in the tank. It gives us drive. It gives us something to work off of. Because I can run chi-squares and regression coefficients all day. I'll put as many stars as you want on a table, but it's not going to make it meaningful. The meaning of a dot is a human, it's a family, it's a place.
I want to underscore that. I think that's a very powerful statement, particularly in this kind of work. And so qualitative, and then kind of turning over to maybe the quantitative, and Sarah Mancini, Sarah Stein got into a great conversation in the first panel with Whitney chiming in as well. I thought, what are those data gaps that really prevent us from being able to answer these types of questions? What do you think we need to do to overcome them?
Man, there's so many different ways we can grow as a movement. We have so many new people in the research space of Sarah 49, the group I was talking about, and research is getting faster. We are turning research out faster. I think that we've really coalesced ever since, I got to shout out Thomas again for putting the debate around an apostrophe to bed. Whether no apostrophe, apostrophe S, S apostrophe. Y'all, it's S apostrophe. We've all agreed on it. I don't know if it's correct or not. I just follow what it is. But ever since then, this question of vulnerability, how do you study a population that's vulnerable without making them more vulnerable? How do we do that better? How do we answer questions that are important to them? And it turns out that keeping the taxes paid, keeping all the family on the land is a big part of this. I'm in full agreement with the previous panel that tax delinquency is actually the fastest way that it is lost in Alabama right now. We see it every year, faster and faster. Oh, I had those taxes paid. We look, you haven't paid taxes in 3 years. You are 1 month away from losing the family property over a couple $100. Like this, how do we study that? And you can go on Govies and look at who's tax delinquent, and you can figure all that out. But if you go and ask a land bank, hey, all out of your percentage, how many were lost to tax delinquency and how many were heirs of? We haven't gotten to that phase yet. How can we break down some of these pieces. And so if we're looking forward, that's one thing. A few of the gaps that I've identified, Whitney mentioned that matriarchs, statistically that is true. Matriarchs inherit land at a much faster rate than men. I think it's something to do with the fact that women on average live 8 years longer. But I also think it has to do with who ends up running the show for the family at that later age. Legal deserts. Many of these places exist in areas where there's no one on the ground to do that. And even if you do have a lawyer on the ground, do you trust them? And if that's the case, do you have a surveyor to walk your land, or are they willing to move that fence line for the highest bidder? I think that there are gaps in research that we haven't really begun to really seriously consider. The deferred maintenance piece of it. How does a family stretch a dollar if the HVAC goes and the floors are sagging? Where do you put that money? Are you going to take a home loan? Are you going to put it on a credit card? What are you going to do if the roof goes? I'm blown away by Vermont. I'm not going to pretend to understand it. I'm going to leave that for Fran Miller in a little bit. But there's not very much, if any, heirs property in Vermont, and it blows my mind that they have just some few things in their tradition that doesn't lead to what we have in Alabama. And then going back to what I think everyone has said all day is the impact of the UPHPA. I can put it up as a coefficient on a table and show that it has an impact, great. But where is it being used best? What provisions are actually having the greatest, most direct impacts? That's something we got to be in courtrooms to see. That's something we got to be talking with families who held on, the success. And then lastly, the one that I don't think I'll ever be able to get over is death taboo. There is a huge taboo in the South about talking about death. The few wills we oftentimes do pass of their own will, pun not intended, but they don't want to talk about it. So you're not going to die, but what do you want to be here in 150 years when you are 280 years old? What are we going to leave behind? What's that legacy planning look like? And we can't talk about death, but how do we go around it then to keep going? Because we can't have this delinquency rate or the lack of wills all over every year. The lack of wills, it just repeatedly sends the family tree into the wood chipper. And a will can save branches. It can save the core part of it. So if we don't work on that, we have to get better. And then lastly, we alluded to earlier, the arrival of urban. You all can ask questions that I had never fathomed. We get to look at new questions that weren't on anyone's radar 5 years ago. So I think that arrival, the new energy, the infrastructure, the questions you all bring in has been a refreshing shift.
It just, I mean, let me just say that I think that this is powerful, and I think that the flip side, I think, is also worth considering, and certainly these are conversations that are already taking place. I think about some of the things that Mississippi State is doing, Federal Reserve Bank of Atlanta kind of leading that, coordinating on that effort. Where research can be most harmful to the communities that we want to serve, what maybe should be avoided, maybe avoided isn't the right term, but how do we incorporate the possibility of that in the work that we're doing?
So, y'all, we can't produce dot maps anymore. If you put a dot map out of every single heirs property household, you just put a target on every single family member's back in a graphic that they did not consent to. Why are you clearing other people's nightmarish financial problem to the world? We know the predators are out there, and even with the law, we know that they can keep going. So if that's the case, no more dot maps. And I'm not saying no more mapping, let's just get creative. Try hex bins, try alternative systems of units to make it really hard to figure out where that family exactly is. And us academics, we love secondary data, so I think it's faster publications, it's more stars on tables. But I think we have to fight the inclination to salami science and just grind out as many studies as possible. And so JP Morgan funded a project with SRDC, Sarah Stein, myself, I was blessed to be on it. And we came to the conclusion that we have 4 principles we're going to try and implement in heirs property space to overcome that vulnerability problem. The first is consent. Don't go putting people's tax information out in the world if they didn't consent to it. And I'll go ahead and tell you, they didn't consent to it. You don't have the time to ask for that. Second, non-malfeasance, meaning do no harm. Like, I got offered a lot of money, I mean, months of paychecks to go teach people how to pray better on heirs property owners. And the day I walked in, I didn't realize who I was talking to. They had my map on the wall, and they were circling counties. So I haven't produced a map in 3 years since then. Not to say don't map, but again, we have to come up with better, more advanced statistical, creative ways of mapping. Beneficence, meaning do good. Like, is your study actually going to help the people who are vulnerable? And that's actually a harder question to answer than I originally thought. But I'm open to any ideas that folks have. And then lastly, autonomy, the ability to make decisions even if they're bad. We're going to let it ride as heirs property. Understood, but here's a draft tenants in common agreement would be huge. If we used to think that clearing title was the only measure we can use as our yardstick, and I don't think that anymore. I think that a family walking out educated with a booklet in their hand is actually a victory in its own right, and we have to acknowledge those. We have this thing in Alabama called the Alabama Heirs Property Alliance. It's a collaboration, the only of its kind, between Auburn, Tuskegee, and A&M, and that's crossing race lines there in ways that have never happened before. We printed 40,000 books about heirs property. It's really pretty. It's called Heirs Property in Alabama, and those $40,000 worth of books were gone in less than a year. Wow. The demand is there. So if the demand is there, how do we get faster at reaching people? How do we get faster at the education? We got a podcast now, so that's going faster. We've got, it's called On the Air. We've got so many, we have an opportunity to be creative to reach people where they're at. How do we do that better, and how do we use this opportunity to its full potential?
Quick follow-up here. On the Air podcast, can you tell people how they can access it?
Yes, it's available through Alabama Cooperative Extension. It's called ACES, ACES. It's run by an amazing Tuskegee resident who her name is Jamie Martis, PhD, and she goes around interviewing families, practitioners, people from the front line, but also she refers to it as the fence line, because in rural areas, a lot of times you're looking at these issues from your parcel and not willing to leave. That's been a huge resource. We have all of our resources available there. Thank you to the lawyers who read it and made sure that we weren't giving bad legal advice. But meeting people where they're at is a bigger challenge than I initially thought.
Powerful, just powerful statement that I think reflecting the realities of what it means to do a type of research serving vulnerable communities. And I heard you bring up that, just being aware of ways in which that work might be well-intentioned, but could actually undermine exactly the communities that you want to serve, and then listing a set of principles that can help to guide you. So certainly want to make sure that remains lifted up. As we come kind of into the final third of this conversation, I'm certainly want to now pivot to thinking about who are the right stakeholders. I mean, we at Urban certainly we like to think a lot more about research to action. That not only do we sit and do systematic and high quality work, but that it has impact and influence, particularly for those that are oftentimes in need, and heirs property at times can certainly be a part of that. And so let me just start with this question of if you had the power to put your research in front of anyone, who are the stakeholders that you would want your research, who you would want to see your work?
This question, the way I would answer it has changed 10 times over the last 10 years. So in the early phase, it was policymakers, and then it shifted to family members, and then it shifted to lawyers, and I think now we've arrived to finance. Like the previous panel spoke about, and I'm sure the next one will, all of this takes money. I could have 10 more research grants, I would love it, another TA or something like that. But if we're not putting money in the hands of the lawyers doing the work to clear the title, to move the family forward. Federal Home Loan Bank has been doing an amazing series of grants, whether it's through Dallas or St. Louis or Atlanta. And that money, I'd argue, has had a bigger impact than much of the research funding that preceded it, which was significantly higher. And so the lawyers doing this outreach, I think what we also need to figure out a way on the ground is to, hey, extension agents coordinating with lawyers. Because if a lawyer's going in and they have the necessary resources, that's the big key here, An extension agent can help get the family's house in order, can get the family tree built. The lawyers don't need to be doing that. They would bleed you dry trying to figure out where your second cousin is. Sorry, y'all are expensive. But we can do that work. We can do 90% of it and just have you check it at the end. And so as we look at the different dynamics around community and everything going on, I'm no longer looking at this as, hey, just give us money to do a good thing. This isn't just philanthropy. I think we look at it as asset preservation because following JC around for the last year, every dollar she spends to clear a title puts 14 back in the family's pocket and regenerates the tax base. And so we need to look at like returns on investment. My friend Christopher Smith at Jacksonville LISC, he's like, you need to learn to talk finance, man. Your heart-wrenching stories are great, but what's the impact and how you bring back the local school? How's that helping repair roads? How does that lead to the brain drain coming back? The kids want to come back. The question is, do they have anything to come back to? And so I want to point out real fast, the law field has done so much work. I've almost learned most of your language. It's Mandarin, but I'm catching up. But the investigative journalism pieces coming from the urban slant have been incredible. And if I could learn to write like some of you all who have written these pieces, everything from Garden and Gun to the city, I mean, absolutely amazing. And they capture the story in ways that I wouldn't have captured it. So I think that going back to that qualitative, these can have huge impacts on policymakers. But for finance, I actually think it's been a lot of the nonprofit research. What Detroit Future Cities did with NCST, National Community Stabilization Trust, Chris and Jordan and what ideas they've brought into the space. Georgia Appleseed has done amazing work in this category too. Hack, Natasha Moody and their work. I think this ground truth, look at scale, ground truth back again. And of course, NCLC, y'all were ahead of the game and remain there. So I think as we do this type of work, pulling inspiration maybe from those who don't officially call themselves academics, I'm more than happy to read that. We need to figure out ways to bridge it a little bit more. But all of this research, I think, again, needs to get the finance in the game.
I mean, excellent point, and I think Scott, I think in the audience, I think hopefully he will bring some commentary in terms of some of the things that he and his team are doing around finance aimed at serving heirs property owners. Let me bring it back to UPHPA. One of the things, and Professor Mitchell really brought this up in terms of, how do you message? How do you think about the messaging? If you're in, one state versus another state, and how can we as researchers kind of take that particular skill and maybe capitalize on it in terms of our own work?
Yeah, I'm from Alabama. I don't mean to say this in a weird way, but I look good in camo. And I can show up and play that Duck Dynasty game all day, and I will, because JC and I were in a church last year, and it's a historically black church, civil rights church, and I was surprised how many white families showed up because they drove an hour from Coleman County, where Scott's from. They drove because there was no one there on the ground to help them there, so they drove down to Birmingham to meet us there. It's an issue that cross-cuts race, it cross-cuts class. And in rural Alabama, out of our 48 rural counties, 47 are shrinking. If we're going to do this work, it can't be racialized, it can't be class organized. It's about impact and keeping families on their family land. And so I'll work with poster children. We call it the poster child model. There's a Century Farm up in Kentucky we've been interviewing to try and get the UPHPA to pass in Kentucky. I mean, look at that dense hotspot here on the map. This was the last map I produced in 2023 at JRSS. And Cassandra Gaither Johnson went to that eastern part of Kentucky where the coal fields and that area she referred to as the white ghettos of Appalachia because it's so dense. You would think you're in the Delta or the Black Belt. And this dense concentration, I don't know how Kentucky hasn't passed it yet. Honestly, it's heartbreaking to think how many families are going to lose their land because they don't have these provisions over the next year. And so we got to get better at messaging. We got to get different actors out front, whether it's National Farmland Trust or Reverend Barber for Moral Monday movement. I don't care. We need to be tapping all actors to get this done.
Let me ask, let me follow up here, and I don't remember if this slide is in your deck or not, but, you know, in terms of where your research is going next.
So I've talked about the gaps. I can't tackle all of them. I'm excited to move into some new ones. I'm trying my hand at urban. We're at urban, so I'm going to show you a little bit of what I've been trying. The first is forwarding of tax bills. We can go to where the property is, the situ address, and it turns out the family's long gone. I should have been going to Chicago. I should have been in Birmingham or Atlanta. So looking at the tax bills, actually, at first I was like, man, I'm not going to be able to go to all these dots. But after giving it some thought, it's actually a family story of migration. And so when you break it down by category, like here, the Gullah Geechee corridor where I was raised is in yellow. You have the Gullah corridor shooting straight up to New York, Brooklyn, and Washington, D.C. So if I'm working on Gullah land in South Carolina, I actually need to be putting on events here in D.C. If you look at the Mississippi Delta over there in blue, the Blues Highway, you would jump on a boat in the Delta and ride it all the way to Chicago. Hundreds of tax bills. And yes, there's the Great Migration going west, but actually it's smaller regional moves. Appalachia there in green, that's the collapse of Coalfield in West Virginia. You can see the Hillbilly Highway just down into Ohio. And then lastly, Alabama. I told my colleagues down in Alabama, I don't know why, it seems like they won't leave the state. And she goes, duh. Dr. Carol Woods is like, you don't leave Alabama. You just move around a little bit. And she's right. But seeing these patterns, if we're trying to fix a family's problem in say, somewhere like West Virginia or Letcher, Kentucky, it doesn't mean that we have to necessarily be where the parcel is. It means we need to be where the family is. And so a lot of Zoom calls, a lot of this type of work. And so diving into urban a little bit further, I'm really interested in the demography, the push. Heirs property is a push factor. You can't loan against it. You can't send your grandbabies to college. The taxes are drying up the tax base as a result. The schools are closing. Your kid's getting bused a county over. So you move in hopes of starting anew. That's a story. We need to be able to understand how this heirs property is pushing young people out, is driving this brain drain from rural and southern places. Second, urban, you all can do things with property values we can't in rural areas. I can calculate the contagion effect of living next door to an heirs property and how many feet away it is from your front door. I can calculate how much it decreases your median property value. This is for Birmingham, Alabama, for a study coming out with Neighborhood Housing Services. I mean, on average, you're looking somewhere between $8,000 to $18,000 decreased property value if you live next door to an heirs property. And so then I went to meet a woman in the north side of Birmingham in Norwood. She had 5 heirs properties butting up against her property. Her property value is entirely gone. All the houses next are completely abandoned and gone. But she's like this oasis in the middle of it. It's the contagion effect, the urban effects. I think we can ask new questions now that urban's in the space. I have to go back to race, though, because heirs property is largely concentrated, at least in Birmingham, Alabama, the most segregated city in the South, in historically redlined neighborhoods. We wouldn't be able to run this in a rural area, but we can definitely run it in, you see percentage jumps by almost 5% compared to non-redlined neighborhoods. I'm trying to urban. This is my first attempt. And then lastly, to throw back to our callback, many people are maintaining the property. They're doing it, they're just doing it in smaller investments more often. And I think that's miraculous. For properties that have not gone to complete collapse, the people who do hold on have done an incredible amount. And then lastly, I'll close on one last point. How do we roll out an effective program? Across the bottom here is the neighborhoods of Birmingham. Across the side, I say we need to take the NCST middle neighborhoods hypothesis of we only have so much resources, put it into areas where it maximizes impact. And so I want to go to places where the average age of homeowners is above 65, because that's the areas that are going to tip the fastest as people pass away. And so a will in that middle area of Arlington, West End, or Inglenook is going to have a bigger impact than East Brownsville or 5 Points South over there on the left. How do we roll out effective strategies and programs is a whole new question we never had to ask before.
This is powerful. This is powerful. I could go, I literally have a few more questions here to ask, but I'm being told that I have to wrap it up. So first, let me apologize to everyone because I don't think I used the word probate or tenancy in common or any of those terms, so I'm sorry for that. But also, everyone just please get a round of applause for Ryan Thompson. Thank you so much, Ryan. Thank you for a terrific conversation. We are going to have a quick break for 15 minutes, and then afterwards we'll come back for our final session of the day, which will be moderated by Olivia Barrow-Strauss from JP Morgan Chase.
All right, welcome back, everyone. Again, my name is Olivia Barrow-Strauss. I am the Vice President of Housing Policy at JP Morgan Chase. It's great to be back with you. My goodness, we have heard a lot today. It has been a packed agenda. I feel smarter, which is exactly how you want to end a day at the Urban Institute. So since we are the last panel of the day, I think it is our responsibility to weave through a lot of the great insights that we've already heard throughout the conversation and hopefully leave everyone with some really tangible, practical tips and takeaways to take back into your own work. So we have truly an all-star set of a cast of characters here today. We have representatives who are coming to speak to us as attorneys, as community development practitioners, as policy thought leaders, really representing the breadth of this ecosystem that touches heirs property issues. One of the things we want to make sure to do in this conversation is zoom out a little bit from the conversation we had, specific to Georgia earlier, and talk about what does heirs property and UPHPA look like in the different states and localities that these panelists are coming from. And so to start, I think we can go down the line. We'll start with JC on the end and just do a quick intro. Tell us who you are, what the work is that you do, and then give us a little bit of a flavor for what UPHPA looks like or does not look like in your state.
Yeah, absolutely. So I'm JC Fisher. I'm a partner at Gregory Varner and Associates in Alabama. I'm also the chief legal counsel for a nonprofit called Clear Landing Incorporated, where we provide free title opinion services to heirs property owners in Alabama. I'm primarily in the private practice space. I do all things heirs property, from prevention and resolution to community education, non-litigation to litigation, and everything under the sun, as well as the real estate litigation that happens a lot for heirs property owners. So boundary disputes, adverse possession, tax lien foreclosure, all those types of the litigation that kind of corresponds with heirs property and heirs property owners. In our state, and I'll talk about this a little more detail later, but Alabama has had the act for more than 5 years now. We passed it in 2014. It was effective in 2015. We have 3 Alabama Supreme Court cases that require the mandatory application of the UPHPA. And so that is so helpful for litigators like me because I have the ability to say, when a judge pushes back, well, Judge, this is established law in our state that the UPHPA must apply. And specifically, the words mandatory application are used in those opinions. And so I really am able to step in those footsteps and use that to my client's advantage. It has been so successful in the state of Alabama that I have never lost a UPHPA case, a partition action under the UPHPA. In every situation, my client has either walked away with the land, walked away with a portion of the land, or if they wanted a sale, the land sold at full market value. And so they actually didn't receive pennies on the dollar. They got the full value of their interest. The UPHPA allows us in Alabama and other states to have different measures of success. So that's the great thing. When Professor Mitchell talked about the 3 pillars, I've used all 3 of those pillars to get success for my clients. And so Alabama is a state where the UPHPA has been widely used and successful.
That's great, and congratulations on your very successful work.
Thank you.
Scott, you've been referenced a few times today for the great work you're doing in New York, so go ahead.
Yeah, hi. First of all, thank you so much for the invitation to be here. You all are my people. I love this conversation topic. I could talk about this all day long. So my name is Scott Kwanowski. I'm the general counsel at the Center for New York City Neighborhoods. We have a wholly owned subsidiary that's a CDFI, a Community Development Financial Institution. It's a loan fund. We do a lot of charitable lending through that subsidiary. I come from a legal services background. For 13 years, I directed a homeowner stabilization project at the City Bar Justice Center, and we've provided free legal services, all things that threaten homeownership, from scams, predation, foreclosure, property tax, liens, all those sorts of things. So New York is kind of, I guess politically the exact opposite of Alabama. Like, it could be further apart. But we've had some really great successes around law reform in the heirs property area. The organization I work at now, we're kind of the nexus of all things. We administer all the state funding for legal services in New York City for housing counselors. We work very closely with the city and state in doing home repair programs, doing first-time home buyer programs, and then we have a lot of other sort of relief programs for people who are threatened with the loss of their home. But we also do a lot of policy work and law reform work. And we work a lot with the media and local electeds. But I'll get into much more detail about the specifics about what we're doing in New York and where we're going. So happy to be here.
Thank you. Fran?
Hi, everyone. I'm Fran Miller. I wear a couple of different hats in this space. I work at the Center for Agriculture and Food Systems at Vermont Law School. And there we have created legal educational materials for heirs property owners and practitioners. I also manage the Heirs Property Practitioner Network, which has been mentioned here a couple of times. And we are a network of 240 or so, growing every day, lawyers who are licensed in about 30 states across the country, most of whom, like JC, provide direct service, some of whom work on policy, including myself and others in the room, but all of whom are really devoted to supporting heirs property owners in making their choice about what they want to do with their land or home. So, yeah.
And since you mentioned educational resources, before we get to Tammy, can you help us out and define a couple of terms that have come up throughout the day?
Sure.
Or any of our attorneys on the stage? Probate and tenancy in common, whoever wants to take it.
Do you want me to start with
Sure.
forms of ownership? So there's a few major forms of ownership, but the default form of joint ownership in, I think, almost all states is tenancy in common. It just means that if you own property as a tenant in common with somebody, and it's not defined on the deed, then you all own an equal percentage of that property. And you can freely sell it, you can freely mortgage it, you can do whatever you want. If you inherit property, then the default form of inheritance is also tenancy in common. So you're going to inherit that as tenancy in common. And that's as opposed to something like joint tenancy with right of survivorship that Professor Mitchell mentioned, where, you know, if you own property as a joint tenant, with rights of survivorship, and it was a way that, for example, gay couples owned property together before we got marriage equality. If one of the joint tenants passes away, the other one gets that entirety of the property automatically inherited when they pass away. It's a lesser version of tenancy by the entirety is if, you know, that's a protected form of ownership when you are married. And there you automatically get the property when you pass away.
Probate.
Oh, and probate. Oh, yeah. So, and probate is when you file when somebody passes away. It's the proceedings in sometimes specialized courts to handle the estate. So you say you probate a will, you probate an estate. You can probate an estate when somebody has died without a will. In New York, we don't call it a probate court, we call it surrogate's court.
Thank you.
And every will has to be probated. It's not valid if it's sitting in a drawer.
Yep.
That's such a great point. As someone who is not an attorney but somehow finds herself spending a lot of time in these kind of conversations, that level setting is very valuable. Tammy?
Yes, good afternoon, everybody. I usually start these conversations by acknowledging that I also am not an attorney, and nothing I say today should be considered legal advice. My attorney advises me to say that before. So I'm Tammy Thompson. I am the founder of a nonprofit in Pittsburgh called Catapult Greater Pittsburgh. And Catapult is an economic development nonprofit focused very specifically on creating intentional economic mobility opportunities for Black families in Pittsburgh. And we do that through two vehicles, homeownership and entrepreneurship. Homeownership, we start with first-time homebuyer education, and we have accidentally found ourselves in the tangle title space for many reasons, but the main reason is we kept getting folks calling us, asking us to help them. And there's some great folks at home, hopefully they're watching, the neighborhood legal systems, the other smaller entities that do this work, but we are the only ones that do not have an income limit to offer this work, which we'll talk about a little bit later. But I'm very happy to be here. This is an incredible panel to be with, and I'm excited to get started.
So I want to spend, JC, you talked about this a little bit in the Alabama context, what UPHPA kind of looks like, how long it's been enacted. But if we can also go back down the line and just spend a couple more sentences on the context of UPHPA in your state at this time.
Yeah, so in Alabama, they passed the act very similar to what the uniform language looked like. I do want to talk about, I'm going to get a little technical because Thomas and I were just talking about this crazy case in Alabama that passed in the 80s that is, it was passed by the Supreme Court. It's technically still good law. It's called Jolly v. Knopf. Fran is a law school professor, and I have also talked about this case a lot. Basically, the case said that not only heirs and family members should have the right to buy out and have a right of first refusal before the property goes out to a third-party sale. That case said that the plaintiffs also have an equal right to purchase the property before it goes out to open market sale, or excuse me, to a third-party sale, which was an auction before the UPHPA was passed. What that means is that in Alabama, historically, developers have served as the plaintiff that file these partition lawsuits. Oftentimes they are lawyers, so they're very well versed in partition law and real estate law. What they would do is they would reach out to a landowner that maybe owned a small fractional interest that maybe moved to Chicago or Michigan or something. They have no ties to the land. They'd say, hey, can I buy your interest? And that landowner would be like, yeah, I don't care. I'm not going back to Alabama. So they would sell that interest to the developer. The developer would pay them cash within 30 days. The developer would turn around and file a partition lawsuit to force the sale of the property. Well, Jolly v. Knopf said that that developer had equal rights with the other heirs to bid for the property before it went to auction. So what do you think that resulted in? The developer outbid the heir 100% of the time. So when the UPHPA passed, Professor Mitchell and the drafters, specifically in Alabama, were very careful to ensure that our buyout rounds, which is one of those pillars, the right of first refusal, allowed only the heirs who objected to the sale to buy out. They were given the right of first refusal. The developers who are initiating the partition lawsuit are not given that right of first refusal. Only the family members are. I have had to argue in court many times that Jolly v. Knopf should not apply because UPHPA sets forth its own language that protects those family members and gives them the right of first refusal, not the developer. This is huge for Alabama because one reason why partition action is so common in our state is because Jolly v. Knopf, this case in the 1980s, existed, and the developers could use it to get clear title to the land very quickly. And so now we are seeing a trend, and I want to give a couple quotes from developers and lawyers that they've given me. Number one, I'm so sorry, Professor Mitchell, but one of the quotes on the record was, "The drafter of this statute should be tarred and feathered." I had an attorney in Pickens County who his whole practice is filing partition actions. And he actually said, I will never, ever take a partition action ever again after having gone through a UPHPA case where the last deed on the property was from 1881. That was the last time a deed had ever been recorded on that land. And it was 337 acres. He said, I will never take a case like this. He has since referred me 3 partition cases, which I greatly appreciate because I know they're in good hands if they're with me. There was another set of developers who are a little Alabama famous in Lee County, Alabama. They are both, well, one of them's an attorney, also a set of brother developers. His whole business model is partition actions as well, which is pretty common. After I took him to the Alabama Supreme Court, he said, I'm retiring. And he retired, but an opportunity in Lee County came up where he wanted to file another partition action. And instead of just jumping into it, he came to me and said, will you teach me how to actually use this statute the right way? And so I look at that as a success because I'm thinking, well, if he's going to do partition actions, at least the due process protections in place will be there for those family members. So that's a lot more expansion than you needed, but I want to show you how practically this is actually happening in Alabama.
Well, I think that's the perfect example, right? Because so much of what we've talked about today is that UPHPA is sort of the baseline, right? These due process protections are necessary, but not always sufficient to fully address every challenge that comes up. In Alabama, this example is perfect, right? Because there are other laws, other case study, et cetera, that are going to complicate implementation. And so having people who are well-versed in the law, in the challenges that families experience, that's what's going to take implementation to the next level. Scott, in the New York context, tell us a little bit about how it's playing out there.
Yeah, well, New York is kind of unique now, I think, because, well, let me tell you how my journey brought me here. So I was doing direct legal services. We do a lot of scam prevention. And I had a couple different clients come in with the exact same story. And this is about almost 10 years ago now. And basically, it was somebody who was living in the family home. Both of these cases were in Queens. And they were being heavily targeted by a speculator, somebody who had already acquired some other fractional interest in their home. And you know, doing scam prevention, you see every single thing in the world you can imagine, and you know the speculator is very cunning, and you know they're it's like whack-a-mole. They figure out one scam and how to get around it. You address that, and they figure out another one. So this is something I'd never heard of. So I just started doing the research and discovered this thing called partition law that I don't remember talking about in law school, and just thinking like how awful it was because it's so unfair and inequitable for the heirs. And so I got some media attention around, and that's how I got connected with Professor Mitchell. And so New York One, which is our local station, they were playing the story with my clients on loop for like almost like a solid week. And Professor Mitchell made a cameo in that loop. A friend of mine who is on my swim team, who's from Tokyo, he said he was visiting home and he saw that playing in Tokyo. Wow. But basically, so that play just sort of describing this predatory scheme and what partition law is and how these actors how these speculators were going after these properties. And immediately, one of our local electeds introduced the UPHPA in New York. And And I saw that, and I was like, wait, slow down. Like, the UPHPA is a great law. It levels the playing field, but it's not necessarily meant to address the issues that you see in an urban context. And there are all these things in New York that I wanted to add to it. And so we got them to pool that, and then, you know, we worked together to modify it and add all these extra protections that were very New York, well, urban specific. One of the main ones is, well, first of all, we modified it. We got them to reintroduce it, and it passed within, it was enacted within 6 months, which is like so quick in New York. And nothing happens that quick. And I think it's primarily because nobody understood it.
Yeah.
Like, it was so weird, and nobody understood. I didn't understand partition law. And so anyway, so we made a bunch of major modifications to the UPHPA, but not too much to where we could still get the Uniform Laws Commission to agree that it's a uniform law. But some of the most important things is we added a mediation part to our version. So as soon as one of these cases is filed, all motions are held in abeyance. They stop until a settlement conference that's court monitored, directed, is held and completed. And during that settlement conference, the parties are supposed to negotiate to try to preserve that home for the family, and they're required to negotiate in good faith. And so it does two things. It slows down the whole process, but it actually also brings you into court with this mediator who's watching and making sure the parties are doing what they're supposed to be doing. So that's had a huge effect. We did a few other things, like we gave the defendants a second opportunity to answer after that settlement conference started, because we know that in the foreclosure context, and also we borrowed that settlement conference part directly from New York's foreclosure laws, because we have very, very protective foreclosure laws in New York, all out of the 2008 mortgage foreclosure crisis. The other thing that we learned out of foreclosure is that unrepresented people, when they receive a summons and complaint, that they have to answer within 20 to 30 days. They have no idea how to do that. And they don't know how to get legal services. But if you send them a notice from the court saying, oh, there's a conference on this date, 90% of the people will show up. And so during that conference, after they show up, the court says, okay, you have 30 days. Here's legal services numbers. You can connect with them. And you have 30 days to put in an answer to this complaint, which is also life-changing. So anyway, that was in 2019. It took us a little while it was COVID hit, so then everything kind of shut down with chaos. But it took us, and then so many people, and especially Brooklyn where I live, and Queens and the outer boroughs, had died, so there were all these title issues. But it took us a very long time to work with the courts to actually implement it. And one of the things, and it came up in the earlier conversation, is like, how do you even get the court to know that it's a partition action? And so, whenever you file an action in New York, you can start the case, but it doesn't get in front of the judge until you file a request for judicial intervention. And so I prepared an addendum that you're required to attach to this RJI when you want to get your case in front of the court, and it says this is a partition action, so it brings it to the attention of the court and everybody else. It's easier to track. So there's a lot more going on.
Can you also say, because Ryan flashed up some of the news stories when he was doing his fireside chat, can you also talk a little bit about the deed theft element here and what you're seeing in Brooklyn? Because I know that comes up a lot in the New York context.
100%. And so the two clients that initially brought their cases to me, they were both, I'm not going to say their names. It was the same actors. And so I got one of our local journalists, I reported back to them. I was like, I've seen this name come up multiple times. Can you please do an investigative report? So they went through land records and court records and found that these speculator bros from Long Island had acquired over 150 heirs property and amassed a real estate fortune of something like $150 million. It was insane, the amount of money that they had amassed, and it's basically every one of these is a heartbreaking story. So that gained a ton of attention. But what they do is, I guess where is really kind of deed theft is all the misrepresentations that they're making to other heirs and family members. Because what they'll do is they'll go to cousin Joe, who lives in LA now, who didn't realize that he still owns an interest in grandma's property, and they'll say, oh, look at this property tax report, and this, did you know that you own some of this a fractional interest in this property in Harlem, and this tax assessment record says that it's worth $200,000, and so it's all this misinformation. A tax assessment isn't the same thing as a market value.
That's right.
And so like those properties which were artificially, the values were artificially depressed because of our historical discriminatory and racial redlining and, restrictive covenant laws. Like you fast forward 50 years, that Harlem brownstone is now worth like $5 million, where it was worth $50,000 50 years ago. So there's so much money to be made there.
I think both a great example of the whack-a-mole nature of this challenge, things can keep popping up, but also the power of the increased awareness and attention in the media and getting stakeholders involved in the solution.
Yeah.
Fran,
Yes.
Vermont.
Yes.
You have a great perspective. You live there. You also, through Heirs Property Practitioner Network and Sarah 49, have a vantage point across a number of states. So tell us a little bit about UPHPA, both Vermont and anywhere else that you're looking.
Well, there's so much to say off of what you guys are talking about. I talked to lawyers across the country, and in preparation for this, I talked to a few people who have used the UPHPA in their states, not in the states that we've heard from here. And overall, almost everybody has the same story, which is it's really helpful. The judge didn't know about it at all, had to school the judge completely on every aspect of it. It slowed down the process so that the client could figure out whether there was a buyout possible. Capital, as somebody said earlier, is always an issue, but also sometimes people have family that they can draw on. And so it just drew out the process so that they could go try to come up with the money. And even when they couldn't, somebody in South Carolina told me her client was able to get a much better offer of settlement because of the fair market value requirement in the law. So I think research would be so helpful on how UPHPA is being used by lawyers across the country and how much deterrent it is really providing. That would be a really helpful thing to see. The overall tone I hear is it's really valuable. Vermont is an interesting place. I'm from New York City. And so I did a paper, Ryan, I don't know if Ryan's in here, Ryan's study, as he said earlier, shows that Vermont doesn't have a lot of heirs property. But you would think that it would because it's a very rural state. It's not wealthy. There are wealthy second homeowners, there are little wealthy pockets, but for the most part, it's not wealthy. And there's multi-generational ownership of land. So it's kind of the perfect, it's a little like Kentucky. It's very white, 99% white. But there's not a lot of heirs property. And so I had a student work with me, and we published a paper recently in the fall called State Incentives for Clearing, why there isn't a lot of heirs property. I don't remember the name of it. Wait, I have it. I wrote it down. State Incentives to Clear Title and Facilitate Property Transfer. And if you Google that, you will find it. And we really looked at why isn't there a lot of heirs property in Vermont? And so there's a number of factors, and I'm not going to get into all of them. Some of it is cultural. There's really small towns. It's a very small state. The land records are held by town. People who run the land records offices are clerks. They know people. They say, hey, Joe, your father died. You need to clear the title to this land. Like, it's literally like that. But also, there are legal and other things that happen in Vermont that could happen in other places that would support what Professor Mitchell was saying earlier. The UPHPA is wonderful, but it's not the whole deal. So Vermont lawyers use deeds to avoid probate. So, Scott was saying what probate was. It's a whole process. Depending on where you are, it can be really, really costly, time-consuming. And so Transfer on death deeds, as Sarah was talking about. There's ladybird deeds, which Sarah also mentioned. There's legal tools that could be used more, even in the states where these things exist, for lawyers to use these things more to avoid probate. Put a beneficiary on your bank accounts. This is what my lawyer told me. Like, I went to get a will. She was like, put a beneficiary on your bank accounts. You don't even necessarily need a will. There's these kinds of things. So Vermont uses a lot of those. A key thing is that in Vermont, there's tax incentives. So if you, we were talking earlier about homestead exemptions and having to prove that you are an owner in order to get a homestead exemption. That is true in Vermont. But if you are able to do that, if you made under $130,000 in 2024, you could get an $8,000 property tax credit. Like, that's huge. And so those kinds of incentives. And then there's a statute that says, basically after 7 years, if there has been no probate, it is easy. There's a procedure to file a probate petition that's very simple. You can clear title, you can file an affidavit of heirship, which we can talk about what that is. But it makes it a very simple process. So all this said, like, states could make things easier for heirs property owners. And I think we have to really, to support the positive impacts of UPHPA, we have to look at all these other policy ways.
Really appreciated your point, Fran, about even just adding a beneficiary to your bank account. That comes up a lot for us. We, at JP Morgan Chase kind of approached this topic from the homeownership lens, is how we, initially got into the topic. But as you start delving into the issue, right, this is really about asset protection, which maybe is what Ryan was saying earlier. And so it's not just real property. Yeah. This is about planning for your assets and your legacy for kind of in all elements of your life. Tammy, you are perhaps the lone outsider here.
The lone outsider.
In, Pennsylvania.
You with us.
We're getting there. For Pennsylvania, we're getting there. But Pennsylvania has not adopted UPHPA yet. However, what's really important in Pennsylvania is that there is really strong bipartisan support. And the House did pass it in June of last year. It is just sitting in Senate gridlock right now. So we've actually been sending letters to legislators sort of, hey, you should bring this up. You should bring this up. You should try to move this forward, trying to advocate to get it moved along. But yeah, we still have not adopted.
Yeah. So how did you come to heirs property, and how are you seeing it kind of play out on the ground? And is that informing any of the potential advocacy or education strategy that you're engaging in?
100%. So I was introduced to heirs property in Pennsylvania. We call it tangle title more often. But I was introduced by an attorney that I hope she's watching, Irene Clark. She was a professor at Duquesne Law, and she started a tangle title clinic at Duquesne Law. And I happened to be working at a nonprofit doing mortgage foreclosure prevention work. And this came up with a family that was in foreclosure. And I was trying to help them get a mediation and get their loan worked out. And they didn't have title. They had been paying the mortgage, the primary mortgage, but the bank did not recognize them as owners. And Irene actually introduced me to heirs property. Fast forward, as a nonprofit focused on creating economic mobility opportunities, Homeownership is a very important program that we offer. We do offer very comprehensive trauma-informed first-time homebuyer education. That has sort of moved us into Tangle Title Clinic because we wanted to add the mitigation of heirs property in our first-time homebuyer. So we provide estate planning education in our first-time homebuyer education, but we also give folks a form to give to their settlement company to put them in the right title position at closing. so that this is sort of mitigating this on the back end. A few years ago, thanks to JP Morgan Chase, has it been almost 3 years now, with some very generous funding, we were able to launch a Tango Title clinic that we call CLEAR, the Clinic for Legal Equity and Home Repairs, Legal Equity and Repairs. Legal assistance and repairs. And we do Tango Title legal work, helping folks clear on the legal side, but also provide very much needed home repairs. And the reason that, well, we didn't start off doing that. We had to actually come back and amend our contract with JP Morgan. But what we found is that going in and helping people get title to a property that is in disarray was not a responsible thing to do. And many folks were living in properties that should have been uninhabitable. I mean, we came across people who didn't have electricity, just being very blunt here, an elderly woman who was defecating in a garbage bag because she didn't have indoor plumbing. Really, really, really bad conditions. And we knew that we had to help folks from a home repair standpoint as well. But so the heirs property came from understanding that in order for people to be responsible, sustainable homeowners, they also have to plan for what happens to that property once they are no longer here.
I mean, one of my favorite things, Tammy, about the work you do and the example you illuminate is that there are so many ways to find yourself an heirs property evangelist, right? And this is something Professor Mitchell alluded to earlier as well, and kind of the point about messaging, right? We can approach this from a property rights conversation, from a home ownership conversation, from a farmland conversation, a disaster recovery conversation. There's a lot of different entry points. And the silver lining of that is that there are a lot of intervention points where we can be really creative with our solutions. I think the title, combining title with home repair programs is one of those really elegant solutions. I can imagine, though, there continue to be funding and financing gaps in this work.
Yeah, it's really expensive. Home repairs are expensive. They are a lot more expensive than they used to be. And that's also one of the entry points for us. We have what we call Basics, which is an emergency financial solution for families that are facing any barrier to moving forward economically. Big range, but home ownership and housing issues were at the top, from rental assistance to mortgage assistance to home repair assistance. And we were making referrals out to other agencies that were funded to do these things. However, many of those agencies would not take those folks on if they were not entitled. And so we were like, oh God, we've got to do something. We have to figure out how to solve that issue, because in Pittsburgh, who's ever been to Pittsburgh? Yeah, Pittsburgh is a very racially segregated city. And most people don't know that. Like, way up north? I'm like, yes, we are probably one of the most segregated cities in the north. And as a result, some of these communities have been disinvested in for a very, very long time. And we have homeowners who have done the work. They're being responsible. They're trying to maintain their properties. But they can't access capital the way other communities can. Some of that is because folks just can't afford it, but most of it is because lenders will not loan in these communities. The properties do not appraise. We're facing a new redlining that includes loan dollars and insurance. We're getting people who get canceled, their homeowner's insurance get canceled out of the blue. Somebody will say, well, we were just walking by and we saw that gutter, and we can't insure you anymore. So it's things like this. These are issues that many of our homeowners are facing, but this home repair piece is the piece that we know we have to continue to do, but like you said, the funding is sparse. It is very expensive, and we have very large populations of families whose homes are in disrepair.
Scott, I'd love to get your thoughts on this. The Center for New York City Neighborhoods has honestly what I think is some nation-leading work in this space. So tell us about the funding structure.
Yeah, Tammy, you couldn't have led me into this better.
Love
so
it.
Thank you. So we have our subsidiary, a wholly owned subsidiary that's a CDFI. It's a charitable mortgage lender. We're regulated by the Department of Financial Services, by the state. I know that now because I'm general counsel, which is kind of crazy. But we also run a lot of the city and state home repair programs on behalf of these public agencies, on behalf of the government. And so we're kind of in that sort of nexus of all things because we do the policy, we do the legal services, and we do the lending. And so, with support from Chase, we've developed some lending products specifically to address that gap in financing and that gap in capital. And it was referenced a lot this morning or all throughout the day, just about you can get the law reform, you can get the education, but where are you going to get the money to consolidate those interests or to buy out the other parties or the investors or the other heirs? Or if you have tangled title, how are you going to get access to these public benefit programs like these home repair programs and other things? And so we've been tackling that issue, and what we've done is, in two different ways. One is specifically what we call the Heirs Property Protection Program, and it's we haven't formally launched it yet, but we've gotten some seed money after we designed the program. And so we've started making loans, and basically the idea is anytime there's heirs property, tangled title, it has to be heirs property. We have a very, very broad definition of what heirs property is. It's not the statutory definition under UPHPA. It's basically anytime anybody has inherited a home from a relative. And so the idea is you don't want somebody who's just probably gone through something traumatic, losing a family member, to then also lose their home because of those circumstances. And so we've designed these loans so that you can consolidate the interest, you can pay mortgage arrears, you can pay property tax arrears. In New York, we have co-ops, which are kind of unique to us. But all these things that could result in that loss after the death of somebody. And so because we're a nonprofit or charitable lender, like our focus isn't on getting all that money back and earning a profit, but we also want to protect that capital. And we have, because we've designed a bunch of other similar programs, or this mortgage assistance program that we started maybe 15 years ago with state money and huge donation for Goldman Sachs. And with that money, we were able to make loans of up to $50,000 to anybody who is suffering any kind of distress, threatened by foreclosure or something like that, loss of home ownership. And so we've already modeled this out, and it's a proven track record. We'll put a mortgage lien on the property. We would never foreclose on that mortgage lien. But if somebody sells the property, they have to pay us back. If a primary lender forecloses on that property, we can recover the proceeds that way. And so we have a very, very low loan loss, which is probably much lower than I think private lenders have because of that. And I think the first iteration of that program in 2010, we've already gotten a third of that money back. And we've only lost maybe 1% of those loans in that 15-year period. And I think for private lenders, it's like 10 times that. But anyway, so we've modeled out these loan programs. We have two kinds. The first is based on that MAP model, the Mortgage Assistance Program, and we make a 30-year loan. These are non-amortizing, no payment, deferred payment loans, no interest, deferred payment loans. We set them at 30 years, and so that, it's way in the future. And the idea is at that time, if another heir has inherited that property, then we'll just, extend that loan maturity date out to that next heir. The second, and that's, so we've designed we have two models. One is the no payment, non-amortizing loan, and the other is an amortizing monthly payment loan. It's a 15-year loan. It's like 3% interest and very low origination costs. And the idea there is that somebody who is locked out of credit markets for whatever reason, if it's truly tangled title and no private lender is going to go in and make a loan, or they just don't have the credit, but they have the income to afford a monthly payment, then we put them into the second tranche of loans. And so so you have folks who are so low income that they can't afford an additional monthly payment, we put them in the first tranche. If it's somebody who has decent income and they just can't get credit, then we put them in the second tranche. And the idea is, we make these loans and we get the capital returned to us eventually, and then we reloan that. And so it's like it's like a revolving loan. And we know it works because we have that experience. So that's everything outside of home repair. And so the home repair programs are kind of unique. And when I first came to this job, I tried to advocate with both the city and the state to get them to expand home repair to tangled title properties, because they're kind of like us, like the city or state, they're never going to foreclose on these home repair loans. They just want to recover that capital of some. They don't want people to like take out a home repair loan and then sell it 2 months from now and just walk away with that city or state money.
Yeah.
They want to be able to recover that, and it's taxpayer money. But all of these home repair programs, or most of them, are usually forgivable loans at the end. So why can't they make loans like this to tangled title properties, to heirs property? Because it's tangled title, so it's very unlikely that anybody's going to be selling that home anyway, because they can't. They don't have clear title. So I tried advocating. I don't think anybody really understood what I was trying to say. But I'm doing another round of that. But we also got a PRI from Robert Wood Johnson Foundation, a $5 million credit facility. And with that, we're doing.
I was just about to say.
People always ask me this, and I'm like, it's a public-related investment, I think. Program-related investment, right? And it's something it's a way that philanthropies can do mission-driven lending to nonprofits like our CDFI. And so with that, we have again, it's a very low-cost home repair program that we're making accessible to tangled title heirs properties.
It's such a fantastic
Amazing
example.
work.
I just want to say
Please.
to all the finance people out there, CDFIs have a lot of possible role
Yes.
in heirs property work. And I think it's like much more to be explored there. And I don't know what you have in Pittsburgh.
I'm going to ask Scott to come and educate our people.
Yeah.
Well, and a few other things too. The Asset Funders Network, they were doing some studies, and we're collecting information now on these loans, and there's this thing called the social return on investment. And so anytime you're a philanthropy, you have an SROI, and if it's 2 or 3 times what the investment is, that's considered successful. So we're getting like 40 times return on social return on investment, because you're talking about, we've already closed 3 of these loans. If we make a $100,000 loan on $1 million profit, we're not just talking about preserving that $1 million of equity, which we are, but we're also talking about, one of the first loans we made was to 2 elderly sisters who inherited their property from their dad, and they were facing foreclosure, and they had both their adult sons and grandchildren and another brother, like another relative, all living in the same household. So when you displace somebody from very affordable housing in a place like New York City like that, and you're talking about 10 people, where's everybody going to go? Wow. They all have to find an apartment or leave the city, and that's black displacement in New York City is a major problem. And so it's, if you're looking to invest.
Yes, I like that.
Scott's available to take questions and inquiries. But I think this really underlines the conversation we've had today. There's sort of 2 main themes that kept coming up for me. One is this point around funding or financing, or how do we, once we get due process protections in place, how do we make sure that there is capital? So that's one. I think Scott and Tammy, you're talking about this perfectly. And then the other is around implementation of UPHPA. And JC and Fran, I just want to give you a second maybe to say a few more words around what does effective and successful implementation look like? I've heard you guys talk about sort of education for judges, or maybe, I've heard a lot of law schools might be creating clinics for sort of training the next generation of attorneys and lawyers in this space. But what do we need to make sure that implementation of UPHPA is effective?
Yeah, I'm going to let Fran talk about the Heirs Property Practitioner Network happen, because I think that's the core of what we need. But implementation in Alabama specifically, I can tell you kind of how it went down and is going down. So, we've had the act for over 10 years. We didn't get our first case law until 2021 that required mandatory application. 2021 was when I started busting up in the courtrooms telling the judges that they couldn't just keep ignoring the act. Because some of them really genuinely didn't know. Most of them genuinely didn't know. Some of them did know. And they were, in my opinion, trying to circumvent the process. Because again, those extra due process protections make the process draw out a little bit longer so that the heirs can kind of get their ducks in a row, right? What I did was number one, we started the Heirs Property Practitioner Network, which Fran will talk about. That naturally brought lawyers within the states together to start talking about these issues in their states. In Alabama specifically, we took a collaborative approach. So Alabama we had an ecosystem, like from the get, as they say, from the beginning. And so we had researchers at Auburn University, and I have to say, of course, Tuskegee University, who had been working on and researching heirs property since the 80s. So we literally stood on their shoulders, the Robert Zabawas and the Connor Baileys, and from there started collaborating research, academia, lawyers, and community organizers to reach the masses. And so we started doing these community-based educational programs, workshops, and seminars where we were incorporating community organizers and lawyers and academics, and then we would invite the landowners to come have those conversations. Then that stemmed into, wait a minute, JC can't be at every single training. We've got to find lawyers that, there's 67 counties in Alabama. We have to find some lawyers. So then we started doing trainings for the lawyers. And so we would have these big CLEs, these 2-day long CLEs, just on heirs property overview, prevention, and resolution, using the curriculum developed by Mississippi State and the National Policy Research Center at Alcorn University. And so then from there, as lawyers started attending trainings in Alabama and nationwide through the Southern Rural Development Center at Mississippi State, we then started focusing on these judges. So every case that I went in on partition, I would, of course, educate the judges. I was really, really lucky to be in courtrooms where the judges were open to being educated. And these are in mainly rural Alabama, where I am the only, not just woman, but Black person, other than the defendants in the courtroom, let's just be honest. And so the opposing counsel and the judges were surprisingly receptive to me teaching them about the UPHPA. And I would literally take a binder and I would say, okay, here's the, this is what we have to do under the statute. That's how it really started. And then, so we would educate them that way. And then it got to the point where I would sit in on the docket. Like maybe I had a case that was just, I was waiting for, and there would be a partition action happening from another set of lawyers. And I could hear the judge say, wait a minute, we need to determine if the UPHPA applies. And I was like, Because, again, Alabama has a Supreme Court case, 3 of them, that say you have to determine whether the UPHPA applies before you can do anything else. And so that worked. And now the goal is to get on the judiciary agenda, the conference. This is something I've been working on for 3 years, to get on their agenda so that I can do a UPHPA training for the judges. That is going to be crucial. But that's Alabama. That's what we've done as far as implementation. And I'll let Fran talk about happen.
Yeah. Well, I think that happen can play a role in doing what JC has done in Alabama all across the country, wherever the UPHPA is legislated, where we have lawyers. And I also think that we've grown very organically, word of mouth. It's not like, we don't have any marketing budget. That's not who we are. And I think that the further we get out into the country and find more lawyers who are doing this work, and the more we do education about the work, the more we will find those lawyers. It's kind of a chicken and egg thing. I think all the work that people have done on the UPHPA, there's also so much more work that is being done and that needs to be done. So just the combination of it all, I think it's really important that we educate lawyers, and JC and some of the other Happen lawyers have developed CLEs, continuing legal education for lawyers, which lawyers have to do to maintain their licenses. So I think we can push that out. I also think the judicial interventions, because all of the lawyers that I spoke to who had UPHPA cases, as I said, the judges had no idea. Whether they wanted to have an idea or not, that's another question, but everybody needs education on how this works. And if they had more education, I think it would be simpler for them to apply.
Yeah.
Yeah.
I want to say one more thing, too.
Go ahead.
Implementation also requires a couple things beyond lawyers being competent. It requires cultural competency.
Yes.
So there's a level of cultural competency that has to be at play. Otherwise, you're going to get the lawyers talking about how Thomas needs to be tarred and feathered because they don't understand why the UPHPA is there at all. When I have to make the sentimental attachment argument of the partition in kind factors, literally you could just hear the, you know, because it's like, the DEI of it all, you know, or whatever. But the cultural competency is important. The capital issue is huge. And I was so glad that that was brought up in the first panel, because I've been saying that to my detriment for years now, and I do get a lot of slack for it. But y'all have to remember, these landowners, it's not just attorney's fees that they can't afford. Court costs. Publication fees, because you have to publish against unknown heirs. And we had a publication fee that was over $3,000 in a county in Alabama. And then the buyout. For them to have any meaningful opportunity to actually buy out an heir and win the buyout round, they have to have the capital to buy them out. In the urban market, because I do a lot of urban partition actions as well, partition in kind, the physical division of the land is not an option, because how do you divide a 0.22 acre lot? All that you have is that right of first refusal, that buyout round. So there's got to be some funding for direct legal services. And what we've relied on has been really private sponsorships and funders up to this point, or families like selling an arm and a leg to be able to afford those costs. And then lastly, I'll add that we've got to empower the landowners who ultimately cannot afford lawyers to know, if nothing else, wait a minute, I have certain protections. If I receive a lawsuit that says that I've been sued with partition, I always empower the attendees of our educational seminars, the landowners, to know that they need to show up at that hearing and say explicitly, I object to the sale. And I've seen it happen where they could not afford an attorney, but they showed up and they said, Your Honor, I object to the sale. That preserves their buyout round under UPHPA. And so we've got to also educate the landowners and bring it down to the language that they want to hear, whatever that language is, so that they can give it in the courtroom if they need to.
That's good.
This education point is so important, and just a little plug for our friends at Urban, that convenings like this are such a great venue for that work to begin. Okay, we're going to move to some Q&A. Okay, these are all good. How do we think?
Modeling Sarah.
Okay, let's start with this one. So if a state were hoping to pass the UPHPA, perhaps like Pennsylvania, what strategies would you recommend?
Wait, let me get another piece of
Go ahead. Let me just talk about our own experience. I mean, I think you just have to look at all the different tools that an advocate has. And for us, it started off with media. So we got media involved, and that got the attention of all the local electeds. That's how we got it introduced. And then you have to get your local electeds involved, speaking to whoever's going to, work with you. And then you have to get public education out there, which was the media part is so important. bar associations, community organizations. I was fortunate because when we got it passed in New York, I was still working at the City Bar Justice Center, which is the foundational arm of the New York City Bar Association. So they have a very intense lobbying arm that really helped us guide this to the governor signing it. But I mean, those are the main things, just looking at all the different tools and trying to, work them.
Yeah, I will add that in preparation for this, and I know, Thomas has stuff to say about this, but I spoke with Jane Sternecki, who is a close collaborator of Professor Mitchell. She's on the Uniform Law Commission. If anybody wants to do this, call Jane.
Call Jane. Seriously.
Call Jane and then call Thomas.
Yeah, call Thomas. Bother him.
But what she said to me is that there's a few barriers that what they're coming up against now. So one is the perception that it's not a problem.
Yes, that's what we're facing.
That our procedures work fine. Yeah. There's nothing, we don't need this. As I think Professor Mitchell said, the bar is conservative. Nobody wants to change anything. So, and it takes work for a legislator to push this forward, to really get in the trenches and understand what's going on and see what the problem is and do work on it. They have to take it as a priority. So I think those are some barriers. But I also think, he had a slide up, coalitions are so critical, and building a broad coalition.
Yes.
I talked to, after the UPHPA was passed in Florida, they had defenders of wildlife. Conservation organizations supported the bill, along with some of the other more civil rights oriented practitioners. So I think that those, in addition to all the things that you're saying, the coalitional, because it is grassroots, and then you have to put pressure on the top.
Yeah.
And then call on other states. So so Jane had me talk to the Oregon folks through the Law Commission about, I gave a whole CLE on UPHPA to their state bar so that they could understand, if we pass this, how does it actually work practically? Again, you could read the statute all day, but how does it actually work? And if, let's do some issue spotting and some scenarios that are real life. And with North Carolina, it was the clerks. North Carolina's big opposition is that the clerks, which are kind of like their probate judges, they think, I'm not going to speak for what y'all think, because y'all might be watching this, but a lot of them feel like it's just too much extra work. And I was trying to show them that in real life, those judges aren't writing their own orders.
Yeah.
Those judges are saying, lawyers, get me a proposed order. Do this, do me a proposed notice. And so, rely on the lawyers. And so rely on other states that have enacted it that are similar to the geographic location where it's trying to, so for Philadelphia, for example, another place similar to that deals with tangled titles, and getting some of that collaboration interstate, not just intrastate.
It's incredibly helpful. We want to make this useful and practical. Tammy, do you feel like you have tips to take home?
Listen, I've been taking notes like crazy. First of all, I do want to thank the Urban Institute, and I want to thank JP Morgan Chase. Bringing folks together to have these discussions is so important. I will say, and I hope my city is watching, because what I want to say is there's data that proves, that actually shows you that if you lay a map overlay over the cities where we're seeing the majority of these cases, 50, 60 years ago, it was the same maps used to draw the red lines.
Correct.
And the challenge that I have in Pittsburgh is Pittsburgh does not like to discuss its racism. They want to pretend it never happened and that it's not happening today. So I've been looking for ways, and because I am a people expert, I am not a legal expert, I'm a people expert, in finding solutions for people's issues around building generational wealth. And this is huge. But I'm struggling to have the conversation with people in a way that they will listen to it. Right? So I have to take the people part out, and I've started talking about it in terms of this being the most affordable form of home ownership you can find, right? Because our city and state say they're concerned with increasing home ownership numbers, and we want to, we have a housing crisis. This is the biggest piece of the housing crisis.
Yeah.
If we mitigate vacancy and abandonment, we can address the market value deterioration that's happened in these communities. And if we mitigate, we can also increase home ownership, true home ownership, where people can actually get loans, and lenders, their ears perk up when I say that, because it's like, oh, wait, we can increase
some money.
Yeah, so it sucks that we have to do it that way, because it is a big racial issue, but finding a way to speak about it for the folks who care about that thing is challenging.
Yeah.
So I appreciate you guys. This is great, really, really good information.
One last thing I want to say in response to that. That's why Dr. Thompson's research, I think, is so important in Birmingham, because Birmingham is facing some similar issues. I mean, Birmingham is a more progressive city as far as like talking about race. We have a black mayor.
Which sounds
He's
crazy,
very young.
right?
I know, it's insane. But the way that Ryan talks about it is starting to get them, because he's looking at the amount of property tax the community is losing, the blighted properties and code enforcement issues that Birmingham is dealing with, and all of these like abandoned properties that are in disrepair. All of a sudden they're like, oh, we got to resolve this issue because these blighted properties are making our city look bad, and we're losing money as a community. So it's so important that we talk about those things, because sometimes we do have to shift the narrative from what we know is a social issue and an underserved community issue to speak more their language.
Yes, the economics of the issue.
Economics of it all.
It goes without saying, this group is incredibly passionate and bright, and these are experts, and I want to make sure that you all know that they are available to answer your questions and talk to you. We are unfortunately out of time, so please join me in thanking this group for sharing their perspective. Now, we will welcome Michael Neal back to the stage to close us out.
Thank you so much, Olivia, and thank you so much, panelists. This was absolutely an invigorating and encouraging conversation. I thank you for giving your time. I have a few short minutes here, so let me first go through some gratitudes that I need to express. Obviously, it goes without saying. It's been said a number of times. I'm going to say it again. Thank you so much to the JP Morgan Chase Foundation. Olivia, just thank you. You've just been a wonderful partner. Your colleagues have been wonderful partners. Thank you so much. Also want to thank the researchers that have worked with me on this work. I said that earlier, I'll say it again. Matthew Pruitt, JP Walsh, Emily Zen, all of them, this work would not have been done without their efforts. I get to look good up here, but they are the ones that did a lot of the real work. So thank you so much. The next thing, I also want to express my gratitude to the broader urban team. You see them running around here. They're the ones that make the whole day work. So thank you to Nico over here, to our colleagues in the lab team over here, Sam and Courtney. Also to those, obviously to Yannicka over here, and to my HFPC colleagues, Daniel and Jung on this side. Just like I said, I get to be the front person, but this would not happen. I cannot do this by myself, and neither do I have the expertise. The other thing that I want to, the other kind of people I want to express gratitude again, and I've already said it, but I want to say it again, are to our panelists. From panel one, coming from Georgia, those that traveled through Atlanta. We all know the challenges that happened in Atlanta, so we definitely want to, number one, thank them for getting here. Number two, make sure that they get back safely. Number two, to Ryan Thompson, for his willingness to come and just give his expert remarks, and then of course to everyone on this panel. I mean, just such an amazing wealth of information. And the reason I say all that is because there were a couple takeaways that I had. I'm going to go through them pretty quickly here. The first one that really just jumped out to me is how everyone came to this issue. That yes, there is a there is an abstract kind of a seemingly abstract kind of conversation around housing, around land use, around the law, around finance. And as researchers, sometimes we are guilty of talking about that in very abstract terms, less personal. But what you also heard was that personal story. People who came because their parents had it, because some relative had it, because they visited and got stories, because they received mail and it struck a chord with them. And I really want to underscore that because that's really what motivates, a lot of the work, that's being done particularly when it gets when it's especially challenging. The second point that I want to really bring up is around the UPHPA. And I think on balance, the evidence does suggest that the UPHPA has been successful, particularly around those three pillars that Professor Mitchell brought up, around the buyout provisions for co-tenants, the adding substance to the preference for partition in kind, and then the restructured sales provision. And again, I'll remind you that it has been passed in 24 states, as well as DC and the Virgin Islands. Now, Professor Mitchell has also let us know that it's probably not reasonable to expect that we get to 50, but I think it is worth saying that it has been successful across a variety of states with a variety of different outlooks on the world. And that, I think, also speaks to both the strategic thinking that Professor Mitchell has brought to this issue, and obviously a template that hopefully all of us can build from. The third point is research can help. Research can help in a lot of ways. Certainly, research starting off in terms of the law. But as Professor Thompson showed us, that it's starting to branch out, and it's starting to branch out in really interesting ways in terms of our methods. Quantitative versus qualitative, in terms of the disciplines, legal, economic, sociology, all of these different areas, and starting to ask new questions as we have better data and better technology. And then lastly, the financing just continued to come up. I'll just echo that, and I think that remains a key issue. Kudos to those that are doing excellent work trying to make progress in that area. And then lastly, let me just say that part of the reason why I specifically invited each of these people here is because I've only been doing this work for 2 years. And I personally am thankful that this community allowed me to be a part of some of the things that they do. And I've come to learn a lot from each of them in conversations. I can think of at least one conversation that I've had with everyone who has come before you in terms of ways in which they have benefited and improved my own thinking. The reason why I say all that is because they're a resource. And go to them, any questions that you have around the way that research is done in terms of the law, anything that you heard, these are the people to go to because they have been in this field, working in this area, making progress in this area, fighting for vulnerable communities for way longer than even I've been doing this research. And even some of the people that are not here that we've heard. I mean, we heard names like Heather Way. We heard names like Christopher Smith, and we heard names like Bob Zabawa. Like, these are other people who, have continued to lay the foundation and really show the way and exemplify a type of leadership in this area that I think is going to be critical toward continuing to help improve the lives for vulnerable communities, including communities of color. Mm-hmm. And with that, the last thing that I will end with is, again, I want to wrap up by saying, thank you again to JP Morgan Chase. Again, this would not have happened without your support. We really appreciate it. I know that Professor Mitchell appreciates the support that they have received through the initiative. And so thank you. Thank you to our audience for coming out. Thank you to all the thoughtful questions that were posed. And I hope all of you get home safely. Thank you again.